my screen, and then we'll proceed.
Okay, great.
Please confirm if you can see my screen.
It is loading.
Okay. Please confirm if you can see my screen now.
Okay, you are sharing the whole screen of yours, so if you can put up the presentation.
Sorry?
I think you are sharing your laptop screen, so if you can open the presentation, see the presentation.
Oh. Just give me a minute. Let me do that again. Is it visible now?
Yes, visible now.
You can see my slides, right?
Yes.
All right. Thank you so much. So I'll just go ahead. Good morning, everyone. I hope we're all doing well. It's glad to be here again today. So I bring you warm greetings from Nigeria. And I've been here before, so I wouldn't waste too much time on the introductions anymore. But my name is Sewese Yajiamondo, and I'll be taking you on the review of some ad hoc institutional rules and conventions on mediation as well. So we'll just go right on to the topic of discussion. And like I would always say, since it's an online setting, if at any point you can no longer hear me, please let me know. And if you have questions or contributions, please feel free to interrupt me so that we can go together, learn from one another, and at the end we'll have a time that is worth it. Okay, so I'll go straight to the point. Like I said, we're reviewing some ad hoc institutional rules on mediation and mediation conventions as well. So I think by now everyone on the call should be familiar with what mediation is. But just by way of recap, I'll go back to just give a brief definition of what mediation is as a voluntary alternative dispute resolution process where a neutral third party helps disputing parties to reach a mutually agreeable settlement rather. So when it comes to mediation in practice, the applicable mediation framework, whether it could be ad hoc or institutional, and this will depend on the parties involved. So they could decide if it's an ad hoc mediation or they want the rules of an institution to apply to the mediation process. And then when we talk about conventions on mediation, we're referring to international treaties, protocols, and legal frameworks that have been established to provide uniform rules for conducting mediations, and then to also promote enforcement of the resulting settlement agreements across jurisdictions. So we'll start with institutional mediation rules, and institutional mediation rules apply when parties designate a specific ADR organization to administer and manage their mediation process. So they submit themselves to the rules of that institution. In our various countries, we have those area ADR institutions, and then globally, we have those institutions that also that will also subscribe to. So under these institutional rules, you will see that the structure provides for a pre-established set of rules. The institutions oversees administrative logistics. They assist in appointing mediators. They handle costs. You know, the costs basically, they are typically fixed cost and then sometimes based on percentage. And then typical examples of this institutional ADR institutions rather, and their rules, as we'll have the ICSID mediation rules stemming from the ICSID as an organization. Then we have the ICSID, that's the International International Center for Settlement of Investment Disputes. Then we have the International Chamber of Commerce mediation rules. And then we also have the UNCITRAL mediation rules, which are like model rules that stem from the UNCITRAL.
Can you hear me? Sorry, I think your slides are not moving.
No, I'm still on the particular slide, institutional mediation rules. Can you see that now?
No, you are still on the first page, which is the ad hoc institutional rules by your name.
Oh, really?
Yes.
What's happening? So sorry about that. Let me understand what's going on. Let me know if it's moving now.
No.
It's not?
No.
Oh, good. I don't understand why. Oh, okay. So I think let me just stop and then share again so that I'll carry everyone.
Okay.
Yes. Can you see my screen now?
Yes.
Okay. So confirm if it's moving now.
Okay. Move. Yes, it is moving now.
Okay. All right. So I already handled the introduction. This is where I am currently.
Okay, great. Thank you.
Thank you. So we're talking about the institutional mediation rules, and we've said that these are mediation situations where specific ADR institutional rules apply to the mediation process, such that the institution handles the the structure of the mediation process in terms of administrative logistics. They already pre-established set of rules that would apply. They also assist in appointment of mediators. They also see to payment of the fees. They are fixed costs or costs based on percentage. And then I also mentioned the fact that popular frameworks that apply across board can be found under the ICSID mediation rules, which is the International Center for Settlement of Investment Disputes mediation rules. Then we have the International Chamber of Commerce mediation rules, and then the UNCITRAL mediation rules that stem from the UNCITRAL model law, as we would see in the course of this session. So those are just the popular frameworks that apply. Then we'll go to ad hoc mediation rules. So ad hoc mediation refers to a situation where the parties themselves opt for mediation as a settlement process, and they do not want to subscribe to any institutional rules. So they would handle everything, the structure of the mediation process. They decide on cost, they decide on the mode of appointment of mediators, the procedural timelines, the venue, location of the mediation, and all of that. So strictly for ad hoc, the entire process is run and managed by the parties themselves. So that's just the clear difference between the ad hoc and the institutional rules. And so most times in practice, as we'll have it, parties would adopt the UNCITRAL mediation rules. When we look at the UNCITRAL model law, we understand that there are typical procedural guidelines that have been put in place by the United Nations to ensure, to harmonize these mediation rules to allow for certainty and predictability when it comes to settlements, international mediation generally, and then enforcement of settlement agreements as well. Okay, so having said that, we'll go to look at the topic of discussion. We'll begin with mediation conventions. And the most, or the primary international framework when you talk about conventions or mediations is the Singapore Convention. So you can't talk about conventions on mediation without mentioning the Singapore Convention. And this convention is otherwise known as the United Nations Convention on International Settlement Agreements resulting from mediation. So it's a landmark treaty, and it was adopted in 2018. And as of 2026 now, about 59 countries have signed the Singapore Convention on Mediation, and about 22 countries have ratified it as their domestic law. So Nigeria is one of those countries that has ratified the Singapore Convention. It was done in 2023. And then I think Ghana has only signed, is a signatory to the convention, but has not yet ratified. So the main purpose of the Singapore Convention, as we will see, is to make enforcement of international settlement agreements easier. And then it aims to promote mediation as a way of resolving international disputes. So when parties know that the mediation process is quick, is easy, it's easily enforceable, they will be, in all situations, they will prefer to opt for mediation as a process of settling their disputes. And then it also aims at facilitating, sorry, let me go back. It also aims at facilitating international trade and commerce as well. So we'll see that we'll look at a few provisions of the Singapore Convention. And Article 1 of the Convention provides for the scope of applicability. So we should note that the Convention applies specifically to international settlement agreements resulting from mediation. So, and it goes further to explain that a settlement is deemed resulting from, or a settlement rather is deemed an international settlement if at the time of its conclusion, at least two parties to the settlement agreement have their places of business in different states, or the state in which the parties have their places of business is different from either the state where a substantial part of the agreement was entered into or performed, or the subject matter of the agreement is closely connected. So what is this saying? What does it mean? If you look at this provision, Article 1, the provisions of Article 1, it divides the scope of applicability into two parts. That's what type of agreements would fall under the convention, or what type of agreement will count as international, and then when it will count as an international agreement. So for what type of agreement will count as an international agreement, what type of agreement it covers. The convention, like I said, applies only to settlement agreements resulting from mediation. That means that the settlement agreement must be in writing. It must be a written agreement that resolves a dispute. And then the dispute must have been resolved through mediation or conciliation or any similar process where there's a neutral third party that has helped the disputing parties reach a settlement. And then we must note that it does not apply to court judgments or arbitral awards or other settlements that have been reached without a mediator. So those are that's the scope of application. And then we already mentioned that it should also count as an international agreement. So it will count as an international agreement if at the time it was signed, there were either of these happens, like as we mentioned, there were different places of business. So at least two parties to the agreement have their places of business in different countries. So a typical example would be maybe a Nigerian company and a Ghanaian company settling a contract dispute through mediation. You see that both parties are they have their businesses in different states. That's the Nigerian state and the Ghanaian state, and they've adopted mediation as a means of settlement. And then the second situation will be where there's a different location of performance. So a typical example is two Nigerian companies, for instance, settle a dispute about a construction project, for instance, that they have in Kenya or in Ghana. You know, they are all from Nigeria, but the business is located in Kenya. That would also fall under international settlement. So if that dispute is settled via mediation, it can be enforced in either of the states, and it will apply as an international agreement. So simply put, the Singapore Convention applies if you have mediated a commercial dispute, you have signed a written settlement agreement from that mediation, and the agreement has a cross-border element. That's either the parties are in different countries or the deal is mainly performed or connected to another country. So once it is connected to another, once all of this applies, you can use the convention to get the settlement agreements enforced directly in any of those countries that have ratified the convention without having to sue again. Okay, so we already mentioned that the purpose of the convention, under the scope, it has been established that the convention provides for a mechanism for the recognition and enforcement of international settlement agreements globally in states that have ratified the convention. So we'll go ahead to look at the provisions of Article 4, where you can rely on the settlement agreement. So under Article 4 of the convention, the provisions of Article 4 here stated says that under the convention, before a party can rely on a settlement agreement, it must meet certain requirements such as supplying to the enforcing court the settlement agreement signed by the parties and evidence that the agreement resulted from mediation. So to prove that a settlement agreement resulted from mediation, the party may adduce evidence of the mediator's signature on the settlement agreement or tender another document that was signed by the mediator indicating that the mediation was carried out, or it can provide an attestation by the institution that administered the mediation, or adduce any other credible evidence accepted by the competent authority in that state. So any of the four situations can be used to prove or rely on a settlement agreement that it originated from mediation when you want to enforce it in that state. Then we'll also go ahead to look at Article 5. So in as much as the aim of the Singapore Convention is to ensure that settlement agreements arising from mediation are enforced in member states or enforced globally, there are also grounds where, regardless of the fact that maybe that state has ratified the convention, there are also grounds for refusal. So these set grounds are divided into about 6, 7, and the first set of grounds are the grounds that a party can use to refuse enforcement or recognition of the settlement agreement. And one of that is when the party is relying on incapacity. So the party to the settlement agreement was under some incapacity at the time that the agreement was entered into. It can be relied on as a ground for refusal. Then where the settlement agreement is considered as not binding, null and void, inoperative, and incapable of being performed, you know, it can also be a ground for refusal. A party can rely on that. Then where the obligations under the agreement have not been performed or are not clear, it can also be a ground for refusal. Then where there was serious breach by the mediator of standards applicable to the mediator. So this is where, as mediators, you have to be careful. You know that as mediators, there are ethical principles that you must adopt or align with during the mediation process. So you must ensure as a mediator that all standards are applicable to the mediation process, or you as a mediator is adhered to or are strictly adhered to. Otherwise, that would be used as a ground for refusal as well. And then where it is seen that granting the relief will be contrary to the terms of the agreement, it can also be refused as well. And then where the mediator, this also applies to the mediator again, where the mediator fails to disclose justifiable doubts. So maybe there's a conflict of interest and all of that, and the mediator fails to disclose, that can be used as a ground for refusal as well. Then you see that for the state itself, where the settlement agreement is to be enforced, they can rely on morality or public policy, the fact that the agreement is contrary to public policy in that state. The court can, on their own, can refuse to enforce the agreement. And then they can, where they see that the agreement itself is non-arbitrable, it cannot be enforced, then it can also refuse enforcement. So these are the grounds for refusal that we should all take note when it comes to enforcement of agreements under the Singapore, or enforcement of settlement agreements specifically under the Singapore Convention. So another convention we'll look at under mediation is the International Convention on Settlement of Investment Disputes, the ACPSEA Convention. So this convention is a convention that was adopted for settlement of investment disputes between states and nationals of other states. So it has gone ahead by virtue of the convention. The ICSID was established as an organization that can resolve disputes between states and nationals of other states. And this convention was entered into in 1965. And at the initial stage, it was ratified by over 20 countries. Currently, that number has increased. It has received global recognition. And then it has also gone further. The initial focus of the convention was strictly on arbitration and conciliation. But over the years, it has also made amendments that have included specifically mediation, and it has also provided for separate mediation rules, as we'll see as we go ahead. So these are basically the provisions of the convention. Chapter 1 creates the various administrative units and the various rules and status, immunities, and privileges of the center. Chapter 2, specifically Article 25, provides for the jurisdiction of the center. And then 3 and 4 provides for, chapters 3 and 4 provide for conciliation and arbitration. And then, as we'll see, up to chapter 10, it provides for amendment procedure, costs, place of proceedings, and then processes as to signature, ratification, and denunciation. So you will notice that by virtue of the provisions here, you would not see any provision as it relates to mediation specifically. And like I said, that's because the initial focus of the convention was on arbitration and conciliation. But over the years, it has amended its provisions to include specific rules and provisions on mediation as well. So we'll look at that later in the course of the session. So we also have the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation. So this is not a convention in itself, but it's a law that it's a model law that has been adopted in over 90 jurisdictions across the globe. And like I mentioned earlier, for parties that it has been adopted by institutions, and then for parties also that want to carry out the mediation process without subscribing to any institutional rules, this is also a law that is mostly adopted, the provisions of the law. So the model law provides for sample mediation clauses, and it also clearly outlines the mediation process and procedures as guidelines. So this model law, so the initial model law was adopted in 2002, and then there was an amendment in 2018. And it was in 2018 that it provided clearly for mediation rules under the model law. And then just like its counterparts, the UNCITRAL model law on arbitration, the model law on mediation also provides guidance to national legislatures on enacting legislation related to international commercial mediation. And the purpose of this law and its aim is to facilitate harmonization of mediation laws globally, so that there's certainty when parties enter into a dispute, they know what to expect, they are already familiar with the process and the procedure, as it were. So we'll look at some provisions of this model law as well. So the scope of application is provided for in Article 1, and it provides that this law applies to international commercial mediation and international settlement agreements. And then it further defines the number, or states clearly the number of mediators that are required as well. So for the purpose of this law, it says mediator means that a sole mediator or two or more mediators. So depending on the case or the situation or agreement of parties, it could be a sole mediator or co-mediators. Then he also goes further to define the mediation process as a whole as a process that is referred to whether by means of mediation, conciliation, or a similar input, as long as the process has to do with the involvement of a neutral third party, and the neutral third party is there to facilitate the process for parties to reach amicable settlement or amicable agreement. It is deemed as mediation. And it states the fact that the role of the mediator is facilitative. So the mediator does not have any right to impose a decision or a solution on the parties. As this has always been the original position of the facilitative mediator. However, as laws have evolved over time, for instance, like the Arbitration and Mediation Act of Nigeria 2023, it further provides that mediator cannot just should not just facilitate the process, but they can go ahead to suggest solutions to the parties, but not impose. So emphasis is always on the fact that the mediator cannot impose solutions on the parties. It must be the settlement agreements must be arrived at willingly. Okay, so Article 15 of the model law also provides for the fact that the settlement agreements or agreements reached under mediation under the laws is binding and enforceable. And this is good because most times people have issues with adopting mediation based on the fact that they have come to believe that mediation is not binding and it does not have an enforceable nature. But Article 15 of the model law clearly provides that when parties subscribe to mediation under the laws, any agreement that has they've come to amicably is binding and enforceable. Then it also provides, the model law also provides for situations where you can rely on the settlement agreement, and it says that a party can rely on the settlement agreement when the settlement agreement is signed by the parties. There's evidence that the settlement agreement resulted from mediation. So to prove that the settlement agreement resulted from mediation, the mediator's signature must be on the settlement agreement. Then there must, if the mediator signature is not on the settlement agreement, there can also be a document that was signed by the mediator showing that that's a separate document from the settlement agreement itself that indicates that mediation was actually carried out. Then an attestation by the institution that administered the mediation when it's an institutional mediation process, that would also apply. And then in the absence of any of the three above, that's signature of the parties, signature of the mediator, and attestation, then parties can rely on the any other evidence that is acceptable to that competent authority. So we'll see that this is similar to the requirements of the Singapore Convention as well. Then there are also grounds for refusal. We'll look at these grounds vividly under the rules as well when we consider the procedural mediation rules. But basically, grounds for refusal apply to where a party says they were incapacitated at the time the agreement was entered into, where the agreement is deemed to be invalid, ineffective, or null and void, where the obligations under the agreement are unclear or they've already been performed, where the terms of the agreement go against the settlement itself, where the mediator, there's mediator misconduct, where there's conflict of interest that has not been disclosed. And then the authority on its own can also refuse enforcement where there's public policy and non-arbitrability. This is also similar to what we have considered under the Singapore Convention provisions as well. So basically, by way of conclusion, the objective of the model law, that's the ancestral model law, is aimed at encouraging the use of mediation by providing greater predictability and certainty, as I mentioned earlier, regarding the mediation process and its outcome. So this is based on the fact that international trade is growing, and there's always bound to be cross-border transactions that are entered into, whether by individuals, small businesses, big organizations. So this gives them a bit of clarity and certainty as to the mediation process and its outcome when they subscribe to it. Or when parties adopt or institutions adopt the model law, and then parties are also educated on the purposes, they are able to willingly adopt mediation as a process. And there's the ancestral model laws have been drafted to assist states to design dispute resolution process that are aimed at reducing cost and then time of disputes. They foster and maintain a cooperative atmosphere, and then there's a flexible and tailor-made solution to conflicts, and they also prevents further disputes and injects certainty into international trade. So basically, that's the objective of the model law. So we'll go ahead to look specifically at institutional rules as they apply. So please, I just want to pause to confirm if you can hear me, if there are any questions or contributions, or else I just proceed. Are we together?
Yes, we are.
Okay, thank you so much, Mr. Boateng. All right, so go to look ahead at the ad hoc and institutional mediation rules. We'll begin first of all with the International Center for Settlement of Investment Disputes mediation rules. So like I mentioned before, the ICSID convention established the ICSID as a center for dispute resolution, and at the initial state for dispute resolution, specifically investment disputes between states and nationals of other states. And then at the initial period, like I mentioned, the focus was on conciliation and arbitration. So its rules did not provide for mediation specifically, but later on, the rules were amended, and they provided for mediation specifically. So these rules, mediation rules, were provided for and adopted in 2022. They took effect in 2022. So we'll look at some of the provisions of these rules. That's the ICSID mediation rules specifically. So Article 1 and 2 provides for, we'll start with the rules generally as to establishment of the center. So Article 1 and 2 provides for establishment of the center, and then the seat of the center as well. And then Article 25 provides for the jurisdiction of the center. It says clearly that the jurisdiction of the center shall extend to any legal dispute arising directly out of an investment. So they are specifically focused on investment disputes. And then this dispute must be between a contracting state and a national of another contracting state. So, and the parties to the dispute must consent to the jurisdiction of the ICSID. The consent must be in writing and submitted to the center. And so when parties have given their consent, the consent is also, it can also not be withdrawn unilaterally. So those are the specific provisions of the ICSID with regards to jurisdiction of the center that we should take note of. And then we can also advise parties accordingly. Then specifically the ICSID mediation rules, as is our focus now. And like I said, it was amended the rules were amended in 2022 and it took effect in 2022. So in 2022, the rules were established, marking the first institutional mediation rules designed specifically for investment disputes. And then the interesting thing about the ICSID mediation rules is based on the fact that they do not just apply, the rules have extended their scope. So with, as it is with the arbitration and conciliation rules under the ICSID, where they are restricted to disputes between contracting states and nationals of other states, the mediation rules of the ICSID have been extended to cover regional areas and then also cover parties that are not members of the ICSID as well. So that's the good thing about the ICSID mediation rules. It's no longer restricted to just those initial rules that existed. Then we'll look at the provisions of the ICSID mediation rules, and we'll see that rules 1 to 4 are the general provisions of the rule, but specifically Rule 2 talks about the mediation proceedings, and it states the fact that the Secretariat is authorized to administer mediation. So this is an institutional mediation now, and it's administered by the Secretariat of the ICSID. And then again, it states the fact that parties must consent in writing, and the consent must be submitted to the center for the mediation proceedings to begin. And then Rule 3 talks about the application of the rules that shall apply to any mediation conducted pursuant to Rule 2, which is the mediation proceedings. Then rules 5 to 7 of the ICSID mediation rules provide for institution of mediation where parties have agreed prior to the dispute occurring. That's at the beginning of the agreement. It has they've subscribed to it as part of the agreement. And then in cases where they have not subscribed to it and then a dispute occurs, they can also institute a mediation process, and it also provides for the process of registration of the request for mediation at the center. So Rule 5 specifically says that if parties have agreed in writing to mediate pursuant to these rules, then any party wishing to institute a mediation shall file a request. That's the process of instituting the mediation process at the center. They must file a request with the Secretary General and pay the lodging fee published in the schedule of fees. The request may be filed by one or more requesting parties or filed jointly by the parties to the mediation. Then if we look at Rule 6, Rule 6 applies to where the parties intend, no, in this case, just a party intends to institute mediation where there's no prior agreement. So it's still the same process. They apply to the Secretariat, they request mediation with the Secretary General, and they also pay the lodging fee. So in this case, the Secretary General now has the duty of informing the other party about the intention of the party to institute a mediation at the center. So we'll have rules 8 to 11, general rules applying to calculation of time limits, then cost of the mediation. Of course, the mediator must be paid. He or she is not doing pro bono work. Then as to confidentiality of the mediation process, and then use of information in other proceedings. So specifically with regards to confidentiality of the mediation process, this has been established. I'm sure that from day one to this point, it has been established that the mediation process is confidential. At every stage of the mediation process, from the beginning of the process to the end of the process, it is confidential. And then I like to always say that in the course of the mediation process, it has a dual layer of confidentiality. So in the joint session, whatever is discussed in the joint session is confidential. And then when the mediator goes into caucus with any of the parties, at that stage, whatever is discussed is also confidential. However, there's an exception where the party allows the mediator to disclose whatever has been discussed in the general session. So confidentiality, confidentiality, confidentiality. It's paramount. It's at the core of mediation from the beginning of the process to the end of the process as well. And the parties also have that duty of confidentiality, not to disclose whatever was discussed. And that's why you will not find settlement agreements in the public domain, just like we have court rulings and all of that in the public domain. For mediation settlements, you will not find them except situations where it is agreed by parties or it is required by law. And then rules 12 to 16 of the ICSID mediation rules apply to the mediator, the conduct of the mediator, the qualifications of the mediator, appointment of mediator, acceptance of appointment, transmittal of request for mediation, resignation and replacement of the mediator. So basically, but specifically, Rule 12 and 13 provides that the mediator shall be impartial and independent. So that is something that cannot be waived. The mediator must always be impartial and independent. And then it also gives parties the right to agree as to the specific qualifications and expertise of the mediator that they want to preside over or facilitate the proceedings. And then Rule 13 specifies that it can either be one mediator or co-mediators, whichever is agreed by the parties. And where it is a co-mediator process, each of the parties will appoint the mediators as well. That's each of the mediators. Where it is one mediator, then they come together to agree as to that particular mediator. Then conduct of the mediation process itself is provided in rules 17 to 16 as to the role of the and duties of the mediators, the duties of the parties, written statements, the first session, the procedure, and then the termination of the mediation process as a whole. So as the roles and duties of the mediators, Rule 17 provides specifically that the mediator shall assist the parties in reaching mutually acceptable resolution of all or part of the issues in dispute. So again, it emphasizes the fact that the role of the mediator is facilitative, and the mediator has no authority, the mediator has no right to impose a resolution on the dispute, on the parties rather. The parties must work towards resolving that dispute voluntarily and willingly. They must agree amicably to the settlement. So the mediator must not impose, and then the mediator is allowed to communicate with the parties, meet and communicate with the parties jointly or separately, as we would see in the practical mediation session, whether in the joint session or a caucus meeting as well. And then it emphasizes the fact that any information, as I've stated earlier, any information received at any stage, whether the joint session or separate sessions, the caucus, is confidential and it shall not be disclosed except with authorization, as we've already stated. So that's it for the ICSID mediation rules. And then we'll go ahead to look at the United Nations Commission Trade Law. That's the UNCITRAL mediation rules. So this applies, the ICSID mediation rules is a typical example of an institutional rule. You know that the focus of our class today is just to review some. There are a whole lot of those institutional rules, both domestically in our various jurisdictions and then globally that we can adopt. But for the UNCITRAL mediation rules, like has already been established, the model law it just provides guidelines, and aims at harmonizing legislative framework for countries, in order to govern cross-border commercial mediations and then enable enforcement of mediated settlements as well. So the model law operates together with the mediation rules. So you would see in the course of us looking at the provisions of the mediation rules that the rules have almost the same provisions with what appears in the model law as a whole. And the rules, as we've established, are basically a set of procedural guidelines that parties can adopt. So with reference to ad hoc mediation process, it's not restricted to ad hoc mediation processes alone. Institutions also adopt the UNCITRAL model law provisions, but specifically for ad hoc mediation processes, where parties wish to administer the mediation process by themselves. The UNCITRAL mediation rules are very, very vital for parties to adopt in order to ensure a smooth mediation process. So Article 1 of the rules, that's the UNCITRAL mediation rules, provides clearly for where parties have agreed to adopt the rules for their mediation process. It says where parties have agreed that disputes between them shall be submitted to mediation under the UNCITRAL mediation rules, then the rules shall apply. Again, there's provision for consent. The parties must agree willingly that these rules would apply. And it says that the rules would apply irrespective of the basis, whether the dispute is contractual or not. So basically, I think what the rules are saying there with regards to whether it is contractual or not is the fact that or this provision generally provides the fact that parties can trigger the rules. So if they have agreed in a contract or in a separate agreement, or even after a dispute arises that their dispute will be mediated under the UNCITRAL rules, then those rules will automatically apply. There's no need for a court or institution to approve it on their own. Once they've subscribed to it, it applies. And then with regards to the nature of the dispute, whether it's contractual or not, it means that the rules apply to contract disputes. Maybe, for instance, breach of contract, payment issues, and all of that, or to disputes that are not contractual in nature. That's not contract disputes like torts, partnership fallouts, or even disputes without any prior contract, disputes that just arise as parties relate. So as long as the parties agree to use the rules, that's the UNCITRAL mediation rules. They don't. It doesn't matter whether there was an original contract between them or not. So basically, in plain terms, if you or if there are parties in a dispute and both of them decide, oh, let's mediate under the UNCITRAL mediation rules, then those rules will govern their mediation process from the beginning to the end of the process. And then you can use it for almost any type of dispute, whether commercial dispute or civil disputes that parties are willing to mediate. So basically, that's what the provision of this Article 1 is saying. And then Article 1 sub 2 provides for a clear definition of the mediation process as well. Then Article 2 provides for commencement of the mediation process. So it clearly states here that mediation in respect of a dispute that has arisen shall be deemed to have commenced on the day on which parties to that dispute agree to engage in mediation. So note here that the mediation process does not begin.
Very nice.
Okay, I don't know. I'm seeing Infinix. Are you trying to say something? Or it was just an interruption. Okay, we'll proceed. So,
Headmaster,
sorry? Okay. Sorry, I can't really hear you, so I don't know if you are speaking to me or it's just an interruption. Okay, so commencement of the mediation as provided in Article 2, like I was saying, it applies to the date that the parties have agreed to engage in mediation. So it is not the date which they entered into the contract. The date that they agreed to engage in mediation is when the mediation process commences. And then there's also a timeline to acceptance. So this will apply in a situation where parties have not agreed to subscribe to mediation prior to the dispute occurring. So where one party decides that, okay, they want to adopt the uncitral mediation rules, there's a timeline for acceptance by the other party. So it says if a party that invited another party to mediate does not receive an acceptance of the invitation within 30 days, so there's a 30 days timeline. Within 30 days from the day on which the invitation was sent by any means, then the party may elect to treat this as a rejection of the invitation to mediate. So if a party initiates the mediation process and does not receive an acceptance within 30 days, the rules provide that that can be deemed as a rejection of the invitation to mediate. So we can take note of that. This is so good because in ad hoc situations, you will not just send an invitation to a party for mediation and then be waiting endlessly for the party to accept. You can use this 30 days timeline and apply to the situation to determine if the party has accepted or rejected the invitation to mediate. Then Article 3 of the rules provides for the appointment, number and appointment of mediators. And it specifically states that there should be one mediator under normal circumstances. Under the original arrangement, there should be one mediator. And this applies to practice, like practical day life, where mediators, where parties want to opt for more than one mediator, you know that the costs will also apply. Of course, all the mediators must be paid and the logistics will come in and all of that. So it's advised that there should be one mediator unless the parties agree otherwise. So where there's more than one mediator, like the mediators shall act jointly. So they shall co-mediate the process together. And then the parties should endeavor to appoint a mediator by agreement. So unless they've agreed to a different appointment procedure, they must agree as to the appointment of the mediator, and they must agree as to replacement of the mediator at any time in the process. And then where they do not want to do that by themselves, they can also seek the assistance of an institution or any other person of repute to appoint a mediator for them as well. Then Article 4 provides for conduct of the mediation process. So the parties, again, are allowed to agree on the manner in which the mediation is to be conducted. Remember that this is most applicable to an ad hoc mediation setting, where it's institutional, the rules of the institution will apply. So they can agree on how the mediation process will be conducted. And if they fail to agree, then the mediator can also, in consultation with the parties, also determine how the mediation process will be conducted. Then he also talks about equality. The mediator shall maintain fair treatment of the parties, and in so doing shall take into account the circumstances of the case, specific circumstances of the case. Okay, so Article 5 provides for communication between parties and between parties and the mediator. That's between parties themselves and then parties and the mediator. So it provides that the mediator may meet or communicate with the parties together or with each of them separately. So again, that is providing for joint sessions or caucus. So whether the mediator is meeting with the parties in a joint session or in a caucus setting, it is allowed. And then it says that at any stage of the mediation process, the parties may submit information regarding the disputes and all other documents that are required. And then again, it emphasizes confidentiality of this information. So when the mediator receives information concerning the dispute from a party, the provisions of Article 5 states clearly that the mediator shall keep such information confidential unless that party authorizes otherwise or indicates that the information should not be kept confidential or expresses consent to disclosure. So these are things that we should take note of, whether we are presiding over an ad hoc mediation setting or it's an institutional process. Confidentiality would always come up again and again. So Article 6 still provides clearly for confidentiality of the mediation process. And then Article 8 is specifically provides for the effects, the binding nature of the settlement agreement. So it says once the parties agrees on the terms of a settlement to resolve all or part of the dispute through mediation, they should prepare and sign a settlement agreement. So the mediation process cannot be complete without a settlement agreement. And then it's also further provides that the parties, if the parties can draft the settlement agreement themselves, or if they deem it fit, request the mediator to support the parties in preparing the settlement agreement. So again, this would apply in an ad hoc setting. And then it further says that unless otherwise agreed by the parties, the mediator or the mediator institution may sign or stamp the settlement agreement. Remember that when it comes to enforcement, these are the things that the enforcing institution or enforcing state will look out for, whether the settlement agreement was signed or either by the mediator or the parties themselves, or it can be attested to by an institution. So there should be that evidence that the agreement resulted from mediation. And then by signing the settlement agreement, the parties agree that the settlement agreement can be used as evidence that it results from mediation, and it can also be relied upon for seeking relief and applicable under the law. So that's the binding nature and the enforceable nature rather of the settlement agreement as clearly provided under the ancestral mediation rules. Then finally, Article 9 provides for termination of the mediation process. So it provides about 6 instances or thereabouts of how the mediation process can be terminated or deemed terminated. So one of those situations is when this settlement agreement is signed by parties on the date of the agreement as agreed by the parties. So once the mediation process gets to the point where parties have agreed amicably and the agreement has been put down into writing as in form of a settlement agreement, then the mediation process is deemed terminated on that date specifically. And then where by declaration of the parties to the mediator, that's the parties themselves declare to the mediator that the process is terminated, is deemed terminated on the date of that declaration. So this declaration can come when the parties say, or either both parties feel satisfied that, the mediation process, they've come to amicable terms, or either of the party, as we see in the third option, feels that they no longer wish to pursue mediation. So in either situation, the mediation process is terminated on the date of that declaration. And then we'll look at other instances too, where by the declaration of the mediator after consultation with the parties. So the mediator must always consult with the parties. So where the mediator declares in consultation, after consultation with the parties, to the effect that further efforts and mediation are no longer justified. So either there's oh God, there's a word I want to use. So the mediation process is at a halt, is no longer moving forward, or parties are not agreeing, or they've seen that there's no need for the mediation process to go on. The mediator can declare the mediation process terminated. And then by a declaration of the mediator after consultation with the parties. So you'll notice in these provisions that at every time that the mediator or the parties themselves are, specifically the mediator, are going to declare that a mediation process is terminated, there must be consultation with the parties, right? So in a situation where the parties have refused or failed to pay the mediation fees, that's what Article 11, paragraph 5 provides for. Article 11 generally provides for costs and fees of the mediation process, cost of the mediators, the mediator fees, the logistic fees, and all of that. So there's also a timeline always agreed to as to which these fees ought to be paid. So Article 11.5 provides clearly that timeline. And so under termination of the mediation, where the parties fail to pay the appropriate fees and within this specified timelines, the mediator can also declare the process terminated after consulting with the parties. And then finally, at the expiration of any mandatory period in the applicable international instrument court order, it can also be deemed terminated. So I think basically that's all that we got to cover. At this point, I want to say thank you for listening. And the floor is open for questions, contributions, and any comments as well. Please, am I audible?
Yes, you are.
Okay, thank you, sir. So I've come to the end of my session. If there are any questions, if there are contributions, I think for this session, those rules are as clearly stated, so we can always go back to read them. And then if we need clarifications, we can also always reach out. So the provisions of the law are there clearly stated. Okay, so Mr. Isaac, I think I will hand over at this point, if you can hear me.
Yes, I can hear you.
All right, thank you, sir.
Okay, thank you so much for your insightful presentation. We are grateful to have you as always. Thank you.
Thank you. Thank you so much. So I'll beg to take my leave at this point.
Okay, thank you, and please do enjoy the rest of your day.
Thank
Yes,
you.
so we
And
continue.
congratulations to all the participants as well.
Yes, thank you. Right, so we are continuing. It has started raining here heavily at our end, and I believe you can hear me. Okay, now it is time to do a presentation on unfortunately, some people have also left. Gloria is gone. Okay, so I hope you can hear me. Hello, can you hear me?
Yes, I can hear you.
Okay, so before we move into that, I'm going to show you another video which is on tenant landlord mediation. It's 20-minute video. Please pay attention to it, watch it, and after that we'll talk about outcome of mediation. So watch it. I want you to identify the skills that the mediator exhibited, and we'll talk about them. Then we'll use it to write our outcome. All right, so
Okay, good afternoon, Dennis and Linda, and I'd like to thank you for coming to the mediation session.
I hope you can hear the sound.
Yes, we can.
Okay.
I know you just went through orientation. Did you have any questions about orientation?
No. I don't know if I want to be doing this.
Why is that?
I don't think this is going to work.
Why is that?
I've tried talking to him before.
Okay, the reason that the mediation will be good is that you're both in the room and you're both here to talk, and I'm here to help you talk through it.
All
and
right.
You have nothing to lose by trying, right?
I don't know, but okay, fine.
Okay, and I just want to remind you of a few things. Everything that's said in here is confidential. It isn't shared anywhere. It doesn't leave this room. I'm impartial. I'm not on either side. So when I'm working with you, I will just try to get you two to talk and come to an agreement. Through the session, I might have a caucus. And what a caucus is where I'll ask one of you to step out, and then I'll talk to one person. Then I'll ask the other one to step out, then I'll talk to the other person. In the caucus, what we say is confidential as well. I can't tell him what you said in the caucus. I can't tell her what you said. But you have to make your own agreements with each other and say to each other whatever it is you want. One of the things I want you to know is I'll probably be taking notes, just so I can, if I have questions, I can ask you a question. After the session, I'll destroy the notes. So, Linda, would you like to start and explain to Dennis why we're here?
You owe money, and a lot of it, and you know that. And I've been waiting a long time for my money. I have it all written out for you. Your rent is $750 a month. You owe the balance of December, which is $250. All of January, $750. And February is 5 days away. You're going to owe another $750 for that. You have 2 late fees, $100. Court fees, $144.50.
Court fees?
Yes. It was $144.50 to bring you here, to get your attention. And double damages of $11.50. So your
Double
total
damages?
That I can get double the daily rent from the time of your default until today. And by statute, I'm allowed that.
I can't pay the rent as it is, and you want to pay double? You want to
Okay.
charge court
Dennis,
fees?
could you just let Linda finish talking?
I want everything by February 1st or move out by the 7th.
Okay. Now, Dennis, could you explain to Linda your side of this
I can't do
situation?
that. I can't move out by the first, and I can't pay you that.
Could you explain to her what the problem was in paying this
Well, I
month?
don't have a job.
Is that my fault?
Well, no, it's not your fault, but I can't pay you because I don't have a job. I will pay you when I get a job.
What is that going to be?
I'm not sure.
Do you have applications out?
I have applications out all over the place.
Okay, so Dennis, I'd just like to ask you a question. Is it possible for you today to make an agreement with Linda on how this is going to be paid?
Well, sure, I can make an agreement. How about if we, I'll have you paid by the end of July.
Oh, forget it. No, just move. Just move. I've waited long enough. You owe me
I don't wanna
31,
move.
44, 50.
I have nowhere to move to, for one thing, and secondly, it's a lot of work to move. I'm looking for a job, and
I
you
run
want to
a
upset my
business,
whole thing.
not a charity.
Okay, so what I'd like to do now is caucus. Dennis, could you leave the room now and I'll caucus with Linda and then I'll come back and get you and then I'll caucus with you. Okay?
Okay,
Thank you.
thank you.
You can see my side, can't you?
I hear what you're saying, so could you explain to me what you would like to happen today?
I'd like my money. I mean, he's got to file a tax return. I mean,
But what if he doesn't have the money? If he really doesn't have the money,
then he's got to get out.
okay. So how long does he live there?
Oh, I don't know, maybe 4 or 5 years. And actually, he was a good tenant while he was paying. He was quiet. He always paid the rent on time. And then all of a sudden the rent stopped. And I was trying to call him and he wouldn't return my calls. And I offered him some kind of a payment plan. Which
What was that?
I think it was, at the time, I was saying like half the rent on the 1st and half the rent on the 15th.
And what did he say to that?
He said, yeah, he'd do it. And then he did it for 1 month and then he wouldn't do it again. And then I'm trying to call him and I'm just sick of it. You know, I just want him out. I want to get my money. Even if he's out by the 7th, I want to get that money. I mean, he owes it to me. I am a business, not a charity.
Okay.
And I have other tenants.
I understand that. So if he moves out, you realize that you have no agreement if you evict him. Unless you make an agreement here, there is no agreement. You could bring him back in again after, but if you don't have an agreement today and you evict him, then you'll have to find.
I think I want to evict him. I think I want that eviction on his record, actually.
What is that reason?
Because he deserves it. He deserves to have an eviction on his record. Screw up his record. I don't care. I mean, I tried to work with him. I mean, I would consider that we were actually friends at one point.
Okay, is there any other agreement you can make with him? Anything, any way you can work with him on this? Because if he doesn't have a job and doesn't have money, there's nothing he can really do about that?
He can start making payments.
Okay, and how much would you think would be fair?
Well,
Do you know if he gets unemployment?
I would think so.
Okay.
Knowing him, he would have applied for it, so I would think he's getting it.
Okay. So what kind of payments would you think would be fair?
$500 a month. And if he gets money back from his tax return, I want that faster.
Okay. Okay, so I'm going to ask you to step out, and then I'll ask Dennis to come in and caucus with him, but I can't tell him anything that you've shared with me. You'll have to share that with him when you come back in. Okay? Okay, thank you. Okay, so Dennis, can you come back in? Okay, so I had a chance to caucus with Linda about this situation, and I'd like to hear from you what your thoughts are.
Well, I don't have I don't have the money. And then on top of it, I pay the rent. And then on top of it, she's asking for these ridiculous fees and double rents. And I can't pay that.
Okay, so what do you think is fair?
I don't know. I like the idea of, I'm sure I'm going to find another job. And when I do, I'll be able to pay her in full.
But
I still don't want to be paying double this and double that and fees and late fees. And, she doesn't understand about not having a job.
But from her perspective, she's in a business, like she said, and she needs you to pay the rent. So if she needs you to pay the rent, what can you offer her?
Why?
If you were in her shoes, would that be an acceptable agreement? To have a tenant that doesn't pay you any rent?
Well, I'm not in. I would rather be in her shoes right now because I don't have a job.
But if you were in her shoes, would that be an acceptable arrangement? To have a tenant live there without paying rent?
I suppose not.
Okay, so what would you propose? That would be fair to you, fair to her, and something that you could actually do. Are you getting unemployment now or anything?
I get a small unemployment. It's not enough to even talk about.
Okay, do you realize that she does have the option to evict you? And she has mentioned it. You mentioned that you don't want to move out.
I don't want to move out. That's
a
terrible time to be moving. It's the winter time for one thing. And
I understand, but can you understand from her perspective that you have to offer her something?
She'll just have a vacant property anyway. What difference does it make? No one's going to move in the wintertime.
Well, at the same time, if she evicts you, then it goes on your record. And when you go to look for another place to live, it's going to make it a lot harder for you because now you'll have an eviction on your record. So what could you offer her so that we can put it in a contract? It doesn't go on your record. You have a place to live until you get a job. What could you offer her?
Well, I guess I could sell my mother's jewelry. I received it upon her death, so I could sell that and pay her. But I'm not going to pay any doubles or any late fees.
Okay, when she comes back in, you can talk with her about that to see if she'll waive that fee.
Okay.
But how much do you think you could pay her then if you sold the jewelry?
Well, I could pay her in full, I guess.
Okay. And when do you think you could do that by?
I'm sure I could get that done by the end of February.
End of February? So you're saying that you wouldn't give her any money till the end of February?
That's correct.
So that would be a month and a half that she wouldn't be collecting any rent?
This is already the end of January.
So all of February?
Yeah. Well,
could you do it a little sooner?
I might be able to, but
again, put yourself in her shoes. Would you?
I don't want to sell it to the first guy that makes me an offer. I want to be able to check it out and make sure I'm getting maximum value. I don't like selling it at all.
Well, but she said you hadn't paid January rent. You owe $250 on December, and to ask her to let you go for another $750,
that's only $1,000. Here she's looking for $3,100, and I owe her $1,000. It's
actually that's
ridiculous.
Could you add it up on what it would be? What you're asking her to give you credit for?
Well, I'm willing to pay the $250 for December and $750 for January, and then I'll owe her for February rent.
Okay, so that's $1,750. You want her to give you credit.
She's asking for almost double that, which is.
So if she goes to court and the judge awards her that, then not only would you have an eviction on your record, but you would owe her $3,144.50.
I suppose that's true.
So you really need to make an agreement with her.
I suppose.
I don't want
an eviction. You're right.
And you don't want this amount on your record either.
Then I would, just because someone gets an eviction, they get some money awarded to them doesn't mean they're going to get the money.
That's right. But
she's going to have to wait for it one way or the other. She's going to have to wait for the money.
Except if you're
evicted. And if I get something like that on my record, I'm not going to be in any hurry to pay her at all.
Well, you're going to also have a very hard time finding a place to live.
I might, but that doesn't get her any money.
Okay, so you're willing to risk an eviction?
No,
It's-
I'm not. I'd just as soon not.
Okay, so
I told her I'd pay her when I got a job.
Okay, but she said that she wants it sooner.
Yes.
So what
she
can you
does.
offer her?
Well, like I said, I could pay her, if I pay her the $1,750 by the end of February.
Okay, can you pay anything today or this
No.
week? Nothing at all.
No. I got to eat. I've got to, put gas in my car. I got a cell phone bill. It's
That probably
that
won't
cable
concern
I
her,
got to pay.
but that won't concern her. What she's concerned about is the rent that you owe her.
Yes, of course she is. But
And she might say, well, why do you need your cell phone or why do you need your cable when you don't pay me my rent?
I got nothing to do all day, and now I'm not going to have cable.
That's
I
not
can't
her
find a
concern,
job
though.
without a phone.
But that's not her concern. Her concern
Well, it
is
may not be, but it's
this
my
money.
concern, and that's what I can do.
Okay, so you're willing to risk an eviction and not give her anything.
Well, I can't give her anything right now, for sure.
Okay, so when is as soon as you could give her anything?
I think that if I had till the end of February, I can give her that $1,750
In full?
I know I can get that stuff sold. If I sell it before that, I'll give it to her before that.
Okay, so I'm going to call her back in and she'll make a proposal to you, then you'll have to make your proposal to her and we'll see what happens. Okay?
Okay.
Okay, so Linda, can you come back? Okay, I had a chance to talk this with both of you, and like I said, it's up to you to make any agreements with each other. So I'll start with you, Dennis. Do you want to make your proposal to Linda?
Well, I can pay you $1,750 by the end of February.
What a joke.
That'll
Okay.
get you your $250 for December and your $750 for January and February's rent.
And I have to wait until the end of February to get it?
Do you want to explain
Well,
how you're going to do it?
I have jewelry that my mother had, and I will sell that. But I don't want to sell it instantly. If I sell it sooner, I'll pay you sooner.
Why only $1,750?
Well, that's what I would owe you: $250, $750, and $750.
What about late fees, court costs?
Late fees? Come on! You gonna charge me late fees?
Yes,
I can't pay the rent now. You want to charge me late fees?
It's in the contract. It's in the contract that I can charge you late fees.
Okay, so Linda, what would you like to offer him? You know what he's thinking. What would you think is fair? Considering that he doesn't have a job.
I want him to pay the rents, the late fees, and the court costs. And then if he misses a payment, I want that higher amount. I want to add the double damages in. So because he's here and he's trying to work something out, I'll give him a little bit of a break. But if he screws up, then he owes me the entire amount.
Okay, Dennis? She said that what she wants you to pay is the $250, $750, $750, the $100 in late fees, and the court fees. She's willing to waive the double damages.
Unless you miss a payment.
Except if you miss a payment, then she's going to want the $31,4450.
And I'll wait until the 20th of February.
Okay, Dennis, how?
Okay, so what you're saying is, if I pay you by February 20th, that's the only payment we're talking about, isn't it?
Yes, minus, you can take off the double damages, pay everything else by the 20th. And you can stay. I don't know if you want to stay, but you can stay.
Well, I'll tell you what. I can't pay that late fees. I'll pay the court fees. I'll pay the rents in the court by the 20th, but not that double damages, not the late fees. And if I don't pay it by the 20th, then you can have the other $1,250.
Okay.
I'm quite sure I can
So
sell that.
what it is it's the $250, the $750, $750, the $100 late fees and the court fees, which totals $1,994.50. And she'll.
Not that I don't trust your math, but
Okay. Check it out.
let me see. No, see, you have that 100 in there yet. I'm not agreeing to pay that.
The late fees?
No, I'm not agreeing to pay that.
Okay.
I'll pay this. That's $1,750, isn't it?
Yes.
No, it's
$1,750 for the December, January, February rent.
yes.
Okay, so you're saying you
And I'll
own,
pay the $144.50.
but you don't think
Or maybe we should split that.
you don't.
Haven't I given you enough already?
Well, I don't know.
Okay,
I know,
you
I'm
don't
not
think
gonna
she's
split it.
entitled
I
to the
don't-
late fees,
Well, she didn't need to file this. I mean, that she's racking fees up. That
but she felt that she needed to, and she did file it, so it was an expense incurred by her.
I mean,
So
she's got a mortgage on the property, which I've paid about 7 years of.
Well,
You know, it's not like I haven't
it's a
donated
business.
to this
It's a
project.
business.
okay, but the focus of this conversation and mediation is she either wanted you to pay $31,4450 by February 1st or move out, and you'd have an eviction on your record, and you'd have the $31,4450 judgment against you. So, would you rather make a payment plan with her to pay off the $1,994.50 or move out by February 7th?
Well, I'll pay the $1,750 and the $144.50, then I'll pay the court costs, but I don't want to pay the rest of it, and I'll pay by the 20th. And
Is that okay with you, Linda? Okay.
Yeah, I'll do it.
Okay. And Dennis, you realize when you sign this agreement, if you default on any of these payments, if
Well-
you will end up owing the $31,4450 automatically.
yes, I'll pay it.
Okay.
I'll pay it.
And,
I'll pay it.
and I'll get an eviction judgment against you. If you miss a payment, I get the eviction against you.
Okay. Are you okay with that?
Okay. I know I can get it done by then.
Okay. Thank you. I'd like to thank you both for talking and working this out, and I'll write up the agreement, and then we can both go over it and sign it. Is that okay with you?
Mm-hmm.
Okay, thank you. I'd like to thank both of you for working together and signing this agreement. And I just want you to know that if you miss any payments, you realize that it goes back to this original amount, and she has the right to evict you per the agreement. Okay, and Linda, if by the 20th there's any problems, you can either come call us at the mediation center and we can talk about it,
Okay.
or if there's any problems along the way, just give us a call. Okay, thank you.
Okay. Thank you.
Thank both of you.
Okay, welcome back. I want to hear your thoughts on the video. Hello. Oh, are we there? Can you hear me? Okay, Kenny, your microphone is on. Please go ahead.
Hello, Mr. Sorry.
Yes.
Can you hear me?
Yes, I can hear you.
Um, okay. Uh, um, I think in the video, the mediator has followed up. Um, for me, at the beginning, she explained her role as mediator, and also he talked about the confidentiality.
Okay.
And she explained also the caucus and her impartiality too. And I think along the discussion, first of all, she gave opportunity of to the both party to explain their view on the issue. And I think she did well by listening to one to do the caucus with both parties to have their what they have to propose to settle the issue. And along the way, she make sure she didn't she bring the two uh to talk to each other. So I think that was a good thing. Um, and at the end, the they reach a agreement that they signed. So I think it was a good way to do the mediation.
Okay, great. Thank you. Yes. Next person.
Yes, I think I joined challenges, but I think I noticed that towards the end she facilitated the signing of the agreement, developing and signing of the agreement, and also gave more like a conclusion of how the agreement should be applied, and also the consequences of it. But I also noticed that she nodded before the other person agreed to. So I'm just looking at it in terms of how the non-verbal is more like it's leading before she could hear the other party agree, even if it was obvious.
Okay, great. So thank you. Josephine.
Thank you.
Hello, Josephine. Are you there? Okay, then let's hear from Mr. Ayenchi.
Okay. So thanks very much for the opportunity. I think the mediation exercise was one for when she started creating the process. I think she did have it when it got a bit heated, called for the caucus. The one that was very fruitful. Then when the group came together, I also saw that before inviting the man in, he hadn't actually briefed him from the on what the lady shared. So that kept the confidentiality. Then when the judge order finished, I think she also made it clear to them that you renege on the terms reached here. The lady or the landlady could take up the action. I think that's very positive, very in as much as lessons that are very helpful. Thank
Okay, thank you. Let's Christy, yes.
I noticed that the mediator gave everybody the equal opportunity to express themselves. And then I also noticed that she when after laying down her ground rules, she made sure that when she intervened at the right time for interruption. When the first party was talking and then the second party now started talking whilst the other party was also talking. I noticed that she actually controlled the section very well. Thank you.
Okay, right. Okay, so thank you all for your input. It's good observation that you have made, and becoming good mediator is being able to observe as many mediation sessions that you can. So mediation session is not about maybe getting physical mediation session to watch. Some of them are this being able to watch several videos to evaluate them, review them, and also criticize some of the video to see the good side and where you think the mediator could have done better. This will prepare you to also do better than what the mistakes that were made by the mediator. So that is what we want you to understand. And today, let me recognize Humphrey. I think he has been with us every day throughout the program. So, our facilitator Humphrey, thank you for always joining us. Do you have any thought to share on the video? Hello, Humphrey, are you there? Okay, maybe he cannot hear us. Who is using Infinix?
Those therefore we come on for this 40 million plus, $40 million.
All right, so thank you all, and let's see what we are able to do today. So as I wanted to show you, I'll show you writing an outcome of a mediation session. And yesterday you were given an assignment about Jane, no, not Jane, it was about Lisa, Sarah, and Tom. So do you have your outcomes ready? Hello, do you have your outcomes ready?
Yes, please.
Okay, Christy, read yours.
Okay, so at the end of the mediation session between Sarah, Tom, and Lisa, all parties agreed on one. All the parties agreed that one bedroom will be retained to Sarah, and then the other two will be rented out, and then the money will be shared respectively, one room each for Lisa and Tom. They will be taking one rent for each room at the end of each year. And then secondly, they also agree that all the parties also agree that the art pieces they'll invite somebody to come and evaluate the art pieces and then know how much it will be sold for and then know how much they'll get out of it and then share the money among themselves. And then thirdly, they also agree that they'll get a bank statement and then find out how much they have as in the sum of money that was left as inheritance so that they can do the division properly as well. Thank you.
Okay. Let's move on to next person. Josephine, you are the mediator. Let's hear you. Hello, Josephine. Josephine cannot hear us. Okay. Let's go to Mr. Irenchi. You are also here yesterday. Gloria was also here, but she was busy somewhere. But Gloria, let's hear you. After Gloria, Mr. Irenchi, then we'll go to Kanye. Gloria.
Yes, I had challenges with connecting because of, yeah, but of course, maybe I would start with stating the outcome. I would state what the challenge was, and then state also how what was agreed, and yeah, recap. Thank you.
Okay. Can I hear you? Let me hear you.
Hello, for sure. Yeah.
Yeah.
So the main point of disagreement were the family house, where Sarah expressed a desire to retain part of the family home, while Tom and Lisa wanted the selling of the property. And the second issue was the art collection and also the financial assets. There was some money to share, and that was the key issue. And also the communication between the siblings. So they want to stay together. And the agreed resolution about the family house was that Sarah will retain and occupy a portion of the house, and the remaining portion will be rented out, and the income will be shared equally among the three siblings. As for the art pieces, there will be evaluation so that the art pieces should be sold and proceed share equally and among the siblings. And for the asset, for the money, the cash, that will be divided equally among the three siblings too. After settled state-related expenses. So the three sibling mention the emotional impacts of the on their interactions, and they agreed to maintain communication and preserve the family relationship going forward. So the conclusion is that both the all parties will preserve both the family legacy and future relationship, and they reach mutual settlement of the case. I'm
Okay,
done.
thank you, Kazi. Mr. Irenchi.
Yes, sir.
Yes.
Okay. So thank you very much. The terms of settlement as per case, following the mediation conducted on the 7th day of May concerning the dispute about the estate property of the Mrs. Kwasi Shawachawi, property decent news, where the evidence of the parties have volunteered.
We can't hear very well.
Oh, can you hear me, please?
A bit better.
Hello?
Yes, now we can hear.
Oh, okay, okay.
Right.
Oh, I'm sorry about that. So the terms of settlement on case number 5084/20M, the terms of settlement are entered into by the children parties following a mediation conducted on the 27th day of November.
The voice is gone again.
The voice is okay. Is it okay now?
Yes, it's been on and off.
Oh,
But you go ahead. You go ahead.
okay. So the acknowledgement of the estate as to the family house situated at the Nidaso number 2, and then the collection, the art collection, and then other properties agreed on in terms of the bank account. So I think the parties agreed with the family house. The parties agreed that some of the rooms will be rented out. And then I think with the proceeds from the rent, I proposed a 25, 25, 25 4-part sharing, which is 25 to Tom, 25% to Sarah, Lisa, then 25 would be for the maintenance of the whole family house. And then the sales of the art collection. I think we generally talked about getting an administrator to that. So the provision had been made for the parties to consider an administrator, consider appointing an administrator to see to the evaluation and then sale of the arts. And then the last part would be with the tacit agreement, adoption of this mediation, parties to this terms of settlement shall act in accordance with the provision and maintain constant communication, keep the family and live in harmony. Thank you. Hello.
Yes, thank you.
Yeah, so thank you.
Right. So thank you all for what you have shared. It's a good start to bring the mediation outcomes, and this will set the tone for our discussion. So let's see what we have here. to build on what you have been able to do on your own. Okay, so writing clear and enforceable outcome from alternative dispute resolution processes is crucial for documenting the agreement reached between disputing parties. So documenting what you have agreed with the parties is very crucial in making sure that the agreement reached, you have a record for it. So this note discusses the drafting processes, emphasizes the importance of crafting precise mediation agreements, and address the documentation of mediation outcome and decisions, and explore the legal implication and enforcement of the mediation outcome. So one thing about mediation is that once you finish and there is a mediation outcome, it becomes binding and enforceable. Whilst any party um, who has the outcome can go to court for enforcement against the other party that they have had that outcome against. So it is important for individuals and people going through the mediation should take into consideration and also know that whatever you do, whatever outcome you have during mediation is binding, and you must be careful about what you sign at the mediation process. Because the moment you sign the mediation process, it is no more the whatever that is discussed. The moment you sign, it becomes binding. So you take when parties come, you should be able to explain it to them in that direction. For instance, what the woman was saying that do you understand what you have agreed to do? Do you know the effect of signing this? If you fail to do this, you do know what will happen. Are you okay with that? These are the things that parties are getting themselves into. So if you sign the agreement, if no one forces you, you sign with your own volition, and at the end of the day, there is no evidence to show that you were forced to sign, then it means that you have signed them, and that will be used against you, and there is nothing that you can do. So it is important for us to understand this and also be able to work around it and help parties to do outcomes that will suffice, outcome that when it goes to the court, it will not be thrown out, outcomes that will also stand the test of time. So these are some of the things that we want you to understand from this training, so that you'll be able to practice it well. And for that matter, once you are doing anything, you know that individuals who come before you have a better agreement and understanding of what they are putting their hands under. So it is very critical and key. Right. So moving on. So terms of settlement or mediation agreement, we refer to it mostly as terms of settlement, because if you talk about mediation agreement connotes a lot of things. Because if you say mediation agreement, there can be too many mediation agreements. For instance, if you say mediation agreement can one be an agreement to submit a dispute arising out of the relationship or their contract or any to a mediation. And two, it can also mean that an agreement to mediate, which is called a consent to mediate. So that is also mediation agreement. So normally we refer to it as terms of settlement or mediation outcome or terms of agreement, which makes it more simple and easy to understand that at the end of the process, this is an outcome parties have been able to agree upon and want to use as a basis for the resolution of their dispute. So it is important as we're learning this, we get to understand this and follow through. So settlement agreements are a vital part of mediation process, providing a written record of the various agreements and understanding reached by the parties. So when the parties are talking, they are discussing, they are making agreement, they are making this. At the end of the day, what have we agreed to do? So the understanding reached is well captured so that individuals are able to do that. So a written agreement ensures that all parties have a clear and equal understanding of the resolution terms, reducing potential conflict for misunderstanding or non-compliance. So if you are able to, so one important thing and the reason why we put terms of settlement together is that at the end of the day, nobody will go and say that I did not agree to that. Oh, I don't remember that. Oh, I don't remember we said anything like that. I don't remember we even agree on anything like that. So that these things will not be happening if we have proper terms of settlement or proper mediation outcome. Somebody will not go and say that I didn't agree to do that, so that people will decide not to comply. So non-compliance, and also sometimes conflict after the mediation, and that is what we see happen, especially in Ghana. We have seen many of that where prominent people go and do mediation. At the end of the day, they come and read and say that this is an outcome of the process. Then people will come out and challenge the process that no, this cannot be the outcome of the process because we did not agree. We did not sign this. We did not understand this. And this is what is important, especially in social conflicts. It reduces the aftermath of conflict. So guideline for writing a settlement agreement or mediation or terms of settlement. One, you have to identify all parties. So who are the parties involved? At the end of the day, initially you have identified that we did the thing for them. At the end of the day, when you are writing the terms, parties must clearly be identified. So if it is the parties, the claimant are 10, do you identify all of them? If they are 2, or if they are 1, if the respondent are 10, 2, 1, you identify all of them. So then specify obligations. Detail what must be done, who is responsible. So what have the parties agreed to do? For instance, the Lisa and Sarah and Tom issue. Now they have agreed to preserve the house, but they are going to lease some part or rent some part, which will generate income for them. So now they are going to give 1 to Sarah. That is what they have agreed to do. So what must be done? So then who is responsible for what? So who is going to take the rent money? Who is going to make sure that the rent money is shared to all of us? This is what you must be able to capture and capture it well. So the method and frequency of payment, how is the process going to be shared? Are we going to keep the money till the end of the year, or the moment the money is received, we share? Or at what point do we share the money? These are important various agreements that the parties have to, it has to be specific and concise so that anyone who picks the agreement know that, oh, they agree to do A, B, C. So example, John Doe agrees to transfer ownership of the vehicle with VN 12345 to Jean on August 15, 2024. So John Doe will transfer that vehicle with a specific registration number to this person on a specific date. On, not on or before, either by this date, by 15th, or on. If it is on. But normally I prefer using on instead of by. But we don't encourage as soon as, no, don't use as soon as possible, do not. On or before, do not. Before, do not. You have to stick to on, or if nothing, you can do maybe by. But I normally prefer people using on instead of even by. but the buy is not fatal. Right. So Jane agrees to pay John Doe 5,000 in 2 installments. 5,000 in 2 installments. So by what? 2 installments specific. So 2,500 by August 1, 2024. So you can make it 2,500 on August 1, 2024. And the remaining balance of 2,500 on August 15, 2024. So that it makes it specific. When are you supposed to pay? On 15th August 2024. So if you mix that period, then it means that you have defaulted. And it's not on or before that you say, oh, it is not yet 15th, it's not yet this. No. On this date, if you don't pay, then verification of compliance. Who would identify or who will verify payment? So identify who will verify the receipt of money, goods, or services. So if we say Lisa, Sarah, and how would they know that the tenant has paid the rent? And to whom? And what date will the rent be paid? Which account will the rent be paid to? And how would they know that the rent have been paid? So that they will be able to monitor and know that the money has been received and it is time for sharing, so that it will bring peace to the family. So example, a third-party escrow services will be used to hold the funds until the transfer of ownership is confirmed by both parties. So a third-party escrow service will be used to hold the fund until the transfer of ownership is confirmed by the parties. So if you are saying that a third-party escrow funds account, then it means that we are going to open a joint account where we'll put the money there, or we are going to ask a bank to create a third-party funding account, which will serve as an escrow account. Once the money hits in the account, the bank will notify us. Then the money will now be disbursed. We'll instruct the bank to disburse the money into our various accounts. Then the remaining amount will be in the account for the purpose of renovating the building or maintaining the building. This is how you do it for them. Set clear timelines, specify all relevant dates and deadline. The construction project will commence on September 1 and it will be completed by 31st 1 or be completed on 31st December 2024. So specify all days and clear timelines so that the deadline, you know that this is when you are supposed to start, you are supposed to end by this time. And if you don't complete by this time, you have defaulted. Use plain language, avoid legal jargons. The agreement should be easily understood by all parties. So use what? Plain language and avoid legal jargons. Use language. Is someone trying to say something? So, incorrect. Indemnitor agrees to hold the indemnity harmless from all liabilities arising from the contract. Who can explain this sentence for us? Who can explain this? The indemnitor agrees to hold the indemnity harmless from all liability arising from the contract. Who can explain this? It is what difficult for anyone who picks the agreement to be able to what assign meaning to it. So it is important to be clear and concise. Company A agrees to cover any cost Company B may incur due to any issue with the provided equipment. Is it not simple and straightforward? So company A, which may be AfCCoDR, have agreed to cover any cost which may be incurred by ACPSEA in cure due to any issue with the machine provided or equipment provided. It makes it simple and easy. Then avoid vague language. So they're incorrect. The contractor will start work as soon as possible. As soon as possible, when? So correct, the contractor will begin work on the roof repair no later than 10th August 2024 or on 10th August 2024. So 10th August 2024, simple, straightforward. Then realistic agreement. Ensure terms are practical and achievable. Test relatives of the commitment made. So you see what the woman was doing in the video. Are you able to do that at this end? Do you know that if you default, these are the consequences? Are you sure that you can do that? How are you going to do that? And he said, I'm going to sell this, I'm going to do this, I'm going to do that. So test, ask questions. So the tenants agree 1,200 in rent monthly. If the tenant is late by more than 5 days, a late fee of $50 will be applied. So find out during caucusing if you are owing somebody and you say that you pay 1,200. Find out from the person, how are you going to pay? What is your, are you able to share with her what is your monthly earnings? Do you earn anything in the month? How much do you earn in the month? If the person is earning $1,000 and the person is saying that he's going to pay someone $1,200 rent in monthly, would the person be able to pay? It is obviously no. So these are certain things. Once you are coming to the agreement, make sure that the agreement that they make will be realistic and the agreement can work. And in the agreement that will not go and fail. Address all issues and cover all relevant issues, but avoid extraneous matters. Don't bring matters that doesn't concern you as a mediator. Don't bring matters that the parties have not discussed on the table. Don't bring matters which are not part of the issue. So the parties agree to resolve dispute through arbitration if disagreement arise regarding the quality of work performed. If that is what they want to put in there, they put in there. But you are not the one who put in there for them. Consequences for breach. Outline the consequences if the agreement is breached and specify who will monitor the compliance. If either party fails to meet their obligation, they will be subject to a penalty of $500 payable to the other party. Future dispute solution. Include a clause for resolving any future dispute. So, for example, in the event of a disagreement, both parties agree to mediation before pursuing any other action. So, depending on them, if you tell them and they agree. Then organize the document well. Organize the document. Use numbers or bullets to list each provision separately. So make it point by point, point by point, point by point. So list each side separately. So point by point, point by point, point by point, point by point. We do it point by point. So use numbers or bullet to do that. Avoid blame. Focus on future compliance rather than assigning fault. So your outcome should not blame anyone. We have even told you that if they utter words which they have used certain verb language, you are supposed to sanitize, rephrase to sanitize the language. So in an event that they have also you get to the writing stage and they are bringing other extraneous matters which are going to blame the other party, desist from including them in the agreement. For instance, in the mediation, the claimant apologized to the respondent or the respondent apologized to the claimant. No. If it is a relationship issue, then somebody has apologized and they have repaired the issues. Yes, parties having gone through series of deliberations and discussions have agreed to leave in harmony and to have good relationships going forward. So that should cater for that. But do not go and say that party A apologized to party B, and the party, upon the sober reflection, party B also forgave the other party A, and that they hug and they forgive each other. No, don't bring that in the agreement. And at the end of the day, during the discussion, if the parties agree that, oh, it was my fault, I apologize for that, and the other party accepts, do not go and say that it was party A's fault, and the party A apologized and party B forgave party A. Please desist from that. Don't add any blames. Do not add any blames. Right. So exclude third party, only include parties who were present and agreed to the terms. So when you are talking about third parties, we are not talking about maybe parties that somebody is representing. No. For instance, an adult person is sitting on the table discussing the issues that he brought upon himself. And now he's saying that my parents will pay. The person is beyond 18, he's beyond 21. He's in his maybe late 20s or 30s. And he's saying my parents will pay. Is the parents on the table? No. If your pay, whatever you do, if your parents will pay, that one is it should be our back case. You have to go and engage your parents as to what has happened and whether or not they will be able to pay for you. If you are able to convince your parents and they will pay for you, that is fine. But your parents will not be in the agreement. For instance, maybe you are doing an agreement with a lady and the lady said, my husband will pay. Likewise, a man will say that my wife will pay. No. On the table, your wife or husband is not on the table. So those people cannot be inside the agreement and say that they are going to be the one to pay. If there's someone representing a company and say that yes, the company is going to pay, that is fine, because they are there not on their own behalf, but they are representing a company. They have authority to represent their company. That is different. But when it comes to certain relationships, like my husband will pay, my friend will pay, this person will pay, let me call my daughter will pay, my son will pay. No. If you want to call your children and for them to assure you that they will pay, fine, they will pay you, then you come and pay them. Tell them when you pay them, not when your son will come and pay them. No, you don't entertain that. And you are likely to face these challenges every time. So do not. Then voluntary agreement. Ensure that all parties willingly and voluntarily sign the agreement. They should have the opportunity to consult with an attorney or an expert or other expert. So yeah, the last time I think somebody mentioned that when you are closer to an agreement and the parties, you see that there is an opportunity to resolve the matter. Do it so that if they go home and they come back, they have changed their mind. You don't get worried over that. All that I want to say about that is that when you do a mediation and parties get involved or get to a stage where parties are unable to, or they want to take even the agreement to their house or to go and consult a lawyer or consult somebody before they sign, please give it to them. I don't buy into the idea whereby, oh, they are having an agreement, so let's conclude on that. No. Give it to them. If they don't want to agree, leave it. It is not your agreement. It is not your agreement. It is their agreement. It is their agreement, not your agreement. It is their agreement, not your agreement. So if the parties are unwilling to agree, leave them. If they are unwilling to agree, leave them. It is not your agreement. It is not your agreement. So that is what I want you to understand, that if parties are unwilling to sign, or if you have discussed with them and at the signing stage they say that I want to go and show it to my lawyer, give it to them. It is not your case. It is not your agreement. Give it to them. If they come back and say they won't sign, let them go. You have done your part. but it's not compulsory that you must resolve every matter. So that is what I want to tell you, that do not say that, oh, we have not even signed. When you finish signing, you can go and show it to your lawyer. Don't enter into that pit and say that they should sign before they go and show it. No, don't get yourself involved in that. If they are not willing to sign, leave them. Let them go. Let them do whatever they want to. I remember I did an agreement. We had an agreement. We sat there for a long time at around 8 p.m. at night, and we wanted to close. And they were about to sign. This guy said, "No, I have to go and show this agreement to someone." I said, "Voila, take it." I gave it to them. They came back and they said he will not sign, and that we should do it again. I said, "Okay, what do you want to do?" The other party said, "I will also not agree to what you are saying," and that ends the matter. Because they would have signed and later somebody will be raising questions that I forced them to sign. No. That is what we should aim at. Any question up to this stage?
Yes, sir.
Okay, go ahead.
Okay, so for this back and forth, can we put a determining number of hours or days to end a mediation? That is one. And then should they?
What you said with this back and forth? What is with this back and forth? Can you explain that?
I mean,
Elaborate
if
on that.
the parties are not willing to sign, or well, they say let's go and then consult, and when they come back, they are unwilling to sign and all this. I'm just looking at the number of days that goes into that, and whether they are willing, the parties are willing to also pay for your services, that extra days.
Yeah, you discuss your services with them right from the beginning of the mediation, and let them know that I am charging you, or the center or your organization is charging, or you, the individual, is charging them maybe 5,000 Ghana cedis. And within the 5,000, they have 4 sittings. If they go beyond the 4 sittings, they are going to pay extra amounts. So you deal with them 4 sittings, you schedule and meet them within the 4 sittings. Within the 4 sittings, if you are able to get an agreement, fine. If you don't get an agreement, then it means that they have to schedule and pay another amount. And aside that too, the mediator, you have the power to say that based on the behaviors and the actions of the parties, you think that going forward with the mediation will not be worthwhile. So you want to end the mediation. That is one authority you, the mediator, have, and you can use it to end the mediation. Again, you can also give the parties opportunity that as long as they want to take, if they agree that we want to come back at this time, but give us opportunity to go and consult and come back. If the other party agree, why not? Leave them, it is their case, and come and let them come back. So as for your fees and issues surrounding your costs and everything, let them understand right from the beginning that this is our fee structure. We take 1,000 cedis for mediation session. Every time you meet me, it will cost you 1,000 cedis. So that is it. So the number of times that they meet you, and with the 1,000, every time you meet me, we'll sit for 3 hours for 1,000. So if you want to meet me for 10 times, then you are preparing to pay 1,000, 1,000, 1,000, 1,000 every day for 10 times. So these are things that you discuss with them, and they agree. I have a friend in the US who charges $300 per hour in every mediation. So every mediation he charges $300 per hour. So if it is $300 per hour, so within 2 hours you are spending $600. If you go 3 hours, you are spending $900. So depending on how many times that you want to come, you are ready to. If you are ready to spend, you come. Then they move on with the mediation. So this is how you can structure your mediation. I hope I've answered you. Hello. Hello.
Yes. Can I come in?
Yes.
Yes. I just wanted to find out when writing all this, is there a time frame where it's supposed to be done the same day of the if the mediation has taken just it is done maybe for example maybe 2 hours. I mean 2 days. These statements should be ready that same day, or is there a time frame? I don't know.
Yes, once you are ready, the same day should be done.
Oh,
Same day. Once you finish the mediation, same day, the outcome should be put together and the parties will sign. So sometimes you can even have a computer and a printer in your mediation room. Once you are doing the mediation, you'll be typing the outcome. You type, you print it for them to do corrections, you print the final one, and all of them will sign. And you photocopy and give each party a copy, or you can print 3 copies, each party will sign one, then all of them will get the original copies. Or sometimes you can also use their institution that have a form. They have a design form for settlement. So you just fill the form and you write the terms on the parts that the form has provided for you. At the end of the day, you do photocopy. So that means it will be handwritten. You do photocopy and you give each party a copy. You give each party a copy. A copy, if you use handwritten, make sure that you give the parties the photocopy and keep the original so that nobody will go and cancel something on the original one. But if it is print out, you can give each party an original copy. I hope you get that.
yes. Thank you so much.
Okay, great. So let's move on. So mediator's rule. The mediator typically records the agreement, not the parties. So review the agreement with the parties to ensure they understand and agree to the point. So you, the mediator, take the initiative to make sure that you are bringing out the key points that the parties have agreed upon. Then now you read it back to them. That is the revision. You read it back to them. You draft the point, read it back to them. They accept it. Then you now put it into the agreement. So sometimes there may be lawyers involved, and lawyers may be elected. They say that they want to draft the agreement. Yes, let them draft, but when they draft it, take control and review it with with all the parties plus their lawyers. And at the end of the day, what the parties accept becomes the outcome. Then 16, drafting process. Use draft to refine their agreement. Do not hesitate to start all over again if necessary. So as you are there, you are discussing with them and you are doing drafts and other things. Do not force yourself that, oh, this should be a final agreement. No. As correction that the parties want, so far as they are agreeing and they want to make changes and other things, allow them to do so until the matter has ended. Then intent statement. Consider beginning the agreement with a statement of intent, such as the parties agreed to maintain a cooperative relationship and resolve this dispute amicably. To achieve this, they agreed to. So you see how it is. For instance, this can be a preamble for the Lisa and the family matter. So the family, the Lisa or the siblings, the party or the parties. So you can say that maybe preamble. Whereas parties being siblings, and namely Sarah, Lisa, and Tom, having gone through a successful mediation in respect of a family property, which is a building that their parents left behind, an artifact, so you can mention those items. Disagreement over the sharing and the management of that particular items. Whereas the parties having chosen or having decided to use mediation to solve their differences and having gone through a successful mediation process, the parties have agreed to maintain a cooperative relationship and resolve this dispute amicably. So to achieve this cooperative relationship, the parties have agreed to one, that the part of the building, which is the 1 bedroom, which was the master bedroom used by our parents, will be given to our older sister, Sarah. 2, that the remaining rooms of the house will be given out for rent. 3, that the proceeds from the rent will be shared into 4. That each, the next one, so 5, that each party will take 1 out of the 4. Then the next one, that the remaining 1 will be used for the maintenance purpose of the building. Then it means that so you are talking about them one step by step, step by step, step by step. So the remaining, the remainder of the rent, which is 1/4 or 1/4, will be used for the maintenance of the building. Then that the maintenance of the building shall be supervised by Sarah, who will be staying in the place. Then that both parties agree that these terms of settlement serve as final and full settlement of their dispute. Then last one, that's the usual default clause shall be applied, which means that if anyone defaults, then they will go back to the table again. Right, so this will be how you start and end your terms of settlement, right? Right. So showing a sample. So now let me show you a sample of terms of settlement. I hope you can see the screen.
Yes, yes.
Okay, so the African Center for Collaborative Dispute Solution in the matter of alternative dispute solution mediation, or you can simply say that in the matter of mediation, in the matter of mediation, the matter of mediation, AD 2025 Accra, case number, then date, then between this, so the either the company or individual, so the claimant, so SYZ Supplies Limited, represented by John Brown, Managing Director, located at 123 Commerce Street, City A, and ABC Retailer Inc., represented by Sarah Green, Purchasing Manager, located at 456 Market Street, City B. Respondent. So terms of settlement. We, the undersigned parties, having gone through a successful mediation facilitated by AfCoDR by Kezia PM Azuma over the delivery and payment of goods, have agreed on the following terms. So this one just mentioned overpayment to just mention the issue. But if you want to give a preamble, you can also give a preamble where you start by, whereas the issue having arose as a result of So you talk about maybe what the delay in the supply of goods or a breach of which has been alleged by this and this and this, and the parties agreeing to go for mediation, and the parties having gone through a successful mediation have agreed on the following. So right, so that is how you do it. So then you come to agree on the following terms. That's A, B, C retailers acknowledge an outstanding balance of 50,000 owed to SY Supply Limited for the delivery of 1,000 units of product A. Then 2, that ABC Retailers Inc. agrees to pay the outstanding amount in 2 installments, 25,000 by August 15 and August 15, 2024, and 25,000 by September 15, 2024. That AZY Supplies Limited agrees to deliver the remaining 500 units of product A by 10th August 2024. So you can make it the 10th by, you can change it to on instead of by. Then if the delivery is delayed beyond August 10th, 2024, XYZ Supplies will provide a 5% discount on the outstanding balance. Then that the retailer Inc. has the right to inspect the delivered goods upon arrival and must notify AYZ Supplies Limited of any defect within 7 days. That XYZ Supplies Limited will replace any defect goods within 14 days of notification at no additional cost. That both parties agree to resolve any further dispute through mediation facilitated by AfCCoDR before pursuing any further action, and that these terms of settlement are confidential and shall not be disclosed to any third party without mutual consent, except as required by law. That this settlement represents the entire agreement between the parties and supersede all prior negotiations and agreement. So signed John Brown for the SYZ, then signed Sarah Green for ABC Retailers. So then signed by the mediator, then dated July 31st, 2025. So this is what terms of settlement looks like. This is how the structure is supposed to be. So what you did, you have to put them into this structure so that it will be a formal terms of settlement, right? So you can put them into structure. Right. Any question on this? Okay, let's go back. Oof. So putting all the things that we have shared now, one thing that you have to, or the key takeaways that you have to know is that crafting clear and enforceable ADR agreement, there should be clarity and specificity. Use straightforward language and avoid ambiguity or jargons. Don't go and be showing that you understand law. No, mediation is not about law. It's about understanding of the people who have agreed on what they want to do. Comprehensiveness, cover all relevant issues, including dispute solution, timelines, responsibility, and future obligations. Then fairness and neutrality, ensure the agreement is fair and neutral and maintain neutrality. Then legal review, consult a legal expert, especially in complex cases, to ensure enforceability and compliance with the law. Sometimes if you are not sure about certain issues, especially where it is not immediate that you have to draft the agreement. Some of the agreement, you don't need to draft it maybe immediately. Some of them you may draft it and then you send it to the parties for them to review and they will come back and sign. So depending on the issue, you think that it is, so consult the parties, give it to them, let them review. Or you can consult your organization that you are working with. They will review and they will give proper feedback before you meet with the parties. So written agreement, ensure all agreements are in writing, signed and dated. Use electronic signature if legally recognized. So ensure that if you are doing terms of settlement, you must make sure that it is written. Terms of settlement which is not written cannot be recognized, signed and dated. And if you are doing it ODR or online, use electronic signatures to make sure that it is signed where it is legally recognized. So record keeping, maintain detailed records of ADR process, including minutes, correspondence, and supporting document. So when we are saying minutes, we are not saying minutes like the normal minute, the notes that you take. If you are taking the note should be destroyed at the end of the process. So you keep the note until the end of the process. Maybe you didn't finish today, you come tomorrow to continue. So don't just, while we are saying that destroy note to keep confidentiality, you just tear the note for today, no, so that it will guide you on what you discussed yesterday and be able to build up on that. So that is what we mean that maintain it. So maintaining it doesn't also mean that you maintain the note. The note that you take, once you have an outcome, you tear them away. Yes, so you don't keep those things. So the information that you keep, record keeping, information that you keep, your request form, the form that you help them to use to request for the information and then process the mediation. 2, the consent to mediate, or the letter that you wrote to the other party, the communication that you exchange with them. Then the consent to mediate that you sign with the parties, the consent to mediate. Then 3, the outcome of the process, the mediation, terms of settlement. You keep all of this in a file and you keep them. So enforceability, ensure the agreement complies with the legal requirement for enforceability. So compare with the law. Be well versed in your law. If you are in Ghana, your ADR Act is your law. The ADR Act 2010 is your law. If you are in Nigeria, the Arbitration and Mediation Act is your law. So know what the law requires you, how the law wants you to write them. So in summary, writing clear, detailed mediation outcome is critical for ensuring that all parties understand and adhere to agreement upon terms. The mediator plays a clear role or a key role in documenting this agreement and facilitating a fair and enforceable outcome. Remember that the agreement must save face and avoid blames in the agreement. Thank you. Questions? Any question, please?
Yes, thank you so much for the presentation. I would like to find out if all agreements can be monitored. I think in the other video there was there was a case where I think the mediator called to find out how the implementation was done. Now,
I think it was not the mediator, it was them who called the mediator.
It was them.
Yes,
Oh,
who called
okay.
the mediator to say that they have been able to resolve and they are thanking the mediator. I have received such call before where
Okay.
At the end of the day, they came, we resolved the matter for them. When they went away, I've even forgotten, and somebody called me and said, yes, the person has started paying. Thank you so much. God bless you. So they will call, not you, the mediator, calling to find out. You, the mediator, your job ends once the parties have an outcome and they have signed. Your job has ended. So you let them go.
Oh,
And
okay.
you don't create
Thank
any
you.
relationship with them. You don't create any relationship because you never know when another person may bring the person who brought somebody, or somebody may also have a case and bring somebody. In order to be seen as fair, impartial, do not build any relationship with a client. Like the judges don't have any relationship with anyone. Don't build any relationship with anyone. At the end of the day, once you are done with them, you are done with them. Treat them nicely. Once you are done, you are done. You leave them. That is the most important thing to understand.
Oh, thank you.
Okay, right. So I'm going to continue with yes.
Okay, sir.
Ask your question,
Okay.
please.
Okay, sir. So, with respect to the relationship, it's this supposed to protect our neutrality. Um, um, then again, okay, I just hello, sir.
Yes, I'm listening.
So the question has to do with the bit about after the mediation, we are not supposed to have relationship with the parties.
Yes.
They are supposed to call us and then give us the results and the stuff. I'd like to know whether, in fact, there are some cases that you also want to, for instance, in conflicts related and heated ones that you want to also follow. I don't know whether is it advisable to
You said you want to follow.
and then see whether the resolution is actually on. There may be some recommendations that you might want to follow through and see.
So the mediator do not do prognosis, or mediation is not a monitoring and evaluation officer.
Oh, okay.
That's not the work of a mediator. Once your work is done, if maybe with your terms with them, sometimes certain social conflicts may demand that if they agreed, the parties from the beginning agree that the mediator will help them to resolve. At the end of the day, the mediator will assist them to implement the outcome, and the mediator will monitor the situation. Then that one you have been given mandates to do. But normal one-on-one mediation, and uh, you finish the mediation, you are not the one supposed to go and monitor the situation and ensure that the situation has ended well or not. No. Once you resolve the matter as a mediator, once your work is done, your work is done, you leave. If the what you have agreed upon does not work, it is not your duty. The party may call you back, or the institution that engage you may call you back. But the most important thing is that you, the mediator, facilitate communication for the parties to resolve, to reach an agreement, and that the agreement is being reached without any coercion, without any one being forced to sign or agree on anything. Once that is done, and at the end of the day, parties agree that, oh, this is what we have agreed to do, and they sign, that ends it. So you don't need to follow anything. Don't follow them. Don't monitor them. Leave them. You are done. Have you seen any judge following people to see whether or not they have they have paid the other party or not? No, they don't do. All that your work is to facilitate the communication. Once it is done, it is done. They go, if they need you, they will come back. If they are successful, some of them may even call you and call the center and say that yes, we've been able to achieve this and we are grateful to you. So you are not a monitoring and evaluation officer. So don't. Resolution, resolution, resolution. Once you are done, you are done. Thank you. Any
Okay.
other question?
Yes, sir.
Okay.
So let me share a bit of the nuance issue, recent issue we had with the conflict in Nkwanta. I don't know whether it's permissible to share here.
Yeah, you can.
Okay.
So with my organization, the National Peace Council, we entered into a resolution. I mean, we did the mediation in Nkwanta, a tripartite one with the three ethnic groups there. So I think an aspect after the signing of the terms of settlement was to form a peace committee and the staff. Now, after the three parties signing, I think 2 weeks after, we heard in the news that they've gone back to fighting each other again. So I'm caught as the spokesperson for the National Peace Council. I'm caught between the line. How do I comment on this? Because I also witnessed the signing, the mediation process, and then how frankly they all talked, and then their willingness to follow the process. But it appeared they've not actually followed through on that, and now we are picking it in the news that they are fighting again. I don't know. In this nuance case, what will be your advice as an expert mediator?
Okay, so issues like that are more sometimes complicated, and sometimes that the parties own the outcome, or because maybe there were some prominent people sitting on the table engaging them, they were also involved in maybe when the people who were on the table, were they the actual people at the front line, were they the actual parties on the front line? These are some of the issues that sometimes when we are going into conflict resolution, we don't look at. So sometimes we may think that we want the chiefs, we want the assembly, we want the ethnic leaders, but sometimes we ignore the representation. Youth who are at the front line, we ignore them. We ignore sometimes even women. We ignore certain key people who are supposed to be on the table. And some of them, even when the leaders go and they come, they tell them that maybe they have bribed them. You people went and received this. You ate, you went to enjoy, and you didn't even think about our feeling. So were the concerns of the people at the grassroots brought to the table? That is what is important. So if you don't bring the concerns of the people at the grassroots, a lot of time you see an overlaps of the conflict again, because what did we agree to do? And in matters of such, National Peace Council, as example, will go in to resolve the matter. Once the matter has been resolved by National Peace Council, who is supposed to monitor implementation? Is it the National Peace Council, or it is their mandate to monitor after they have resolved, monitor implementation, or there is another institution? Because when it comes to peace and law and order, it's supposed to be by the police. So the Interior Ministry, through the National Security, is supposed to monitor the situation, make sure that the implementation is being done. That is why peacekeeping is done. So if you have been able to resolve that matter, how do we build a peace back? Because having resolved the matter, that is the first step to peace building. So now you start using the peace building mechanism. What did this say we are going to do? How do we do it? How did we agree that we are going to form the peace committees? The peace committee, who is supposed to bring what and who is supposed to bring what to the table? What kind of person is supposed to be on the table? And if that is agreed upon, then you move on to the next step. Who is supposed to monitor? Who is supposed to pick? Because those people on the table, if we are able to bring certain key grassroots people on the table, those grassroots people will serve as an asset for information, because if something is about to happen, they will be an asset who will say that no, we agreed to do this and we don't want to do that. And they can even provide information that my people are not happy, they want to do this, and the security can take action. But sometimes we ignore such people. So as it has happened, maybe you have gone in, yes, the issue has overlapped again. It doesn't mean you did not do a good job. Maybe there was a mishap somewhere. So you have to look at what went wrong in the process. Why did this outcome not succeed? What went wrong? How did it? Who was on the table? Was the person supposed to be there? And the people who were on the table, are they the same people who have gone back to fight, or they are different people who were not on the table, or they are linked to them? How do we get them back on the table? How do we resolve this? How do we make sure that we implement it? Now we begin to ask questions about what has happened, evaluate it, and now look at it thorough. And after that, you can now begin to know where the lines were not or the lines went crooked, and for that matter, you can fix it. So I hope I've answered you.
Yes, sir. Thanks very much, sir.
Okay. Any other question? Okay, so if there are no other questions, I'm going to break us. So we are going on break. We haven't had any break. So we are going to break for 30 minutes, or 30 may be too much. Or let's say 20. Or is 20 okay for you? Let's agree. Hello, is 20 minutes okay for you? It's 12:40 here. Okay, it's 12:40 here, so we come back at 1. All right, so thank you all. Please do enjoy your break, 20 minutes break. Thank you, and bye-bye for now. But don't log off, you can leave it on. Okay, right. Then after his presentation, we'll continue with the role plays to build more capacities in role plays. Right. So let's go. Right, so we're talking about ethics, which are very important when it comes to mediation. Because without ethics, every practice will not enjoy what they are supposed to have. So ethics are guidelines, set of rules that assist individuals to conform to the practice and the dictates of the practice that they found themselves in. So this afternoon we are discussing ethical consideration in mediation. So this session examines the ethical foundation of mediation, duties owned by the mediators to the parties, core professional standards, and the practical ethical challenges in mediation. So why ethics? So mediation relies on parties' trust. So ethics are very important because mediation relies on parties' trust. It is very important. So trust, if parties do not trust the process, you can't have the process going on. So ethics rely on parties' trust. Then mediation also rely on parties' voluntary participation, because we have already indicated that we cannot force parties to go through a mediation process, because they have to agree, they have to voluntarily agree, so out of their own volition to decide that they want to go through the process. So voluntary participation, procedural fairness. So there must also be procedural fairness. There must be procedural fairness, and there must be confidence in mediators' neutrality. So they must have confidence in the mediators' neutrality. So what do they believe that the mediator is neutral? The parties must believe in that. Then also, without ethical standards, mediation loses its legitimacy. So because these are issues that are based on trust, and if you don't commit yourself to the details of the practice, then it loses its legitimacy. So mediation, the nature of mediation is voluntary, it's confidential, it is interest-based, and it's facilitator-driven. So voluntary means that the parties come as without any coercion. Confidential means that what is discussed on the table remains with you till death, unless it is required by law. Interest-based means that parties negotiate based on their interests and their needs instead of their strict legal rights. Then it is facilitator-driven. Facilitator-driven means because there is a third party who is the mediator, who is now in the driving seat telling who to speak at what time, and raising issues, bringing issues to the attention of the parties to drum home a resolution that will work for the parties. So because mediators have no coercive power, ethical integrity is central. Even if you have coercive powers, ethics cannot be downplayed with. Even judges who run down judgments must be guided with ethical standards. How much more a mediator? So source of mediation ethics. Ethical standards arise from the Alternative Dispute Resolution Act. So the Court Act gives certain acts, the act that governs ADR practice. So in Ghana, the Alternative Dispute Resolution Act, which is the Act 798 of 2010, gives certain ethical guidelines on what to follow. The mediator, if you look at it, you talk about mediator with interest. So if there is any conflict of interest, the mediator must be able to disclose any level of conflict of interest in order for the parties to be assured whether to still engage you or not to engage you. If you are affiliated, especially if you are working with certain organization and you are related to any political party, you must disclose for them to know so that the parties may decide whether to continue with you or not. Then court-connected ADR practice also have directions. Every court, every country, if the judicial service is using court-annexed mediation, there are directives, there are directions that they give to the various parties on what they should do, at what point, and at what instances that they must offer that particular assistance. So they also provide that. Then we have institutional mediation rules. So every institution, for instance, if you come to AfCCoDR, we have an institutional rule. So the our rule says what, at what point, what can you do, what can't you do. So what are the processes to follow? So these are institutional. Then we have international mediation ethics instrument. Like we have if you are doing it under ICC have their own standards that you have to follow. If you are doing it on an ad hoc basis using the ancestral model laws or more ancestral rules, you must follow those standards. So ADR recognizes mediation, regulates mediators' duties, and protects settlement confidentialities. And this is very important for us to recognize that. So key pillars of mediation ethics, core ethical principles. Those are core ethical principles. One, neutrality. So are you neutral? Impartiality, are you impartial? Independence, then confidentiality. So now let's explain them one by one. So every one of you take one. When we say something is neutral, when you say neutrality, what comes to mind? Who is going first? Hello. If you don't talk, I will start pointing. Let me see.
Like you are not supporting any of them and not biased, is it?
Okay, yes, you are not supporting any of them. You are seen as being in the middle. Yes. What about
Yes.
impartiality? Who is going to explain for us impartiality? We normally say you are partial, you are partial, you are partial. But what if there is an impartiality? What comes to mind?
Okay.
Yes. Go ahead.
So it involves making decisions or offering advice without being biased and being objective in whatever you say.
Okay. So impartiality, then independence. Who is explaining independence for us? So independence also means that being able to what? Take decisions, act without looking at the somebody looking at you. So some people act because maybe there is somebody directing them to do what they are doing, say what they want to say. But you should be able to act independently as a mediator. Then confidentiality, being able to keep the information that you have received from the parties. Then competence. You, the mediator, cannot work, and you shouldn't be accepting matters that you think that you are clueless about it, you don't even understand the processes, and you're unable to assist the parties. But you look at maybe the monetary value and you just accept. You accept because of the monetary value, not because you are competent enough to do it. So you must also be guided on that. Because if the law says that any parties can choose anyone, they can choose anyone to serve as their mediator. But if you know that the article guidelines which say that the mediator must have at least 40-hour training, a comprehensive training, then you know that you do not have any of such training, but you are still making sure that you want to mediate, which you don't even understand. So that is where the competence comes. Then informed consent. You must make sure that before you conduct any mediation, parties have given their consent. Then, so neutrality of the mediator. So mediator must not favor any party. That's the neutrality. So taking them on by neutrality, parties must not favor anyone. Role is to facilitate dialogue, not to dictate outcome. So your role is to facilitate the discussion, the dialogue, the negotiation process.
For the
not
last and I will teach them you are.
Then perceived bias can destroy the process, even if not actual bias. So if parties perceive a bias, it can destroy the mediation process. Then impartiality, equal treatment of all parties, equal treatment. If you are meeting this one for 30 minutes for caucusing, you meet the other person for 30 minutes. So balance opportunities to speak. If they are supposed to have opening statement for 10 minutes, 10 minutes, 10 minutes, then avoid emotional alignment. If you are not careful, sometimes somebody will narrate their question and you say that instead of empathizing, you go and say, you sympathize. Say, oh, these people didn't do well at all. You are now sympathizing. If you say, I understand how you feel, I mean, this must have been a difficult moment for all of you, but I hope you can look at it. Have you considered this? This means that you are, oh, I understand how you feel. I understand the situation you find yourself in. It means that you are empathizing with them. You are not sympathizing. So don't go and be sympathizing and be entering into the arena with them on the other part. So mediator must withdraw if impartiality is compromised. Then independence, free from financial interest in the outcome. So mediator does not take interest or does not take part of the subject matter. So as I discussed with you the first time, the video that you watched with the animated chameleons, which said that the frog met them and discussed the matter, and the frog took some. If it was mediation, the frog is not supposed to even have interest in the subject matter in the first place, and it should not take part in the subject matter. So you shouldn't go into a family who is fighting or struggling over land, and you want to go and share for them. And after sharing, helping them to share, and you say that the mediator is taking 2 plots or 2 acres. No. If the parties from the beginning agrees that we do not have money, so we are going to use 2 acres of the land to pay you. That is different from you, the mediator, saying that I'll do it for you, but when I finish, I'll take I'm also taking part of the land. I'm taking 2 acres, I'm taking 3 acres. So these are some of the things that you must avoid. No, free from financial interest in the outcome. No personal relationship with the parties. So shouldn't have any, there shouldn't be any personal relationship. I remember there was an issue with a mediator who was mediating someone, and the two parties who were divorcing, and the matter was referred for the mediation, and he got interest in the lady and started sending the lady's message. That is unethical. And as a mediator, you shouldn't do that. You shouldn't do that. Control yourself. you shouldn't do that. Avoid that. Avoid professional conflict. So you must avoid professional conflict of interest. You must avoid that. Then disclosure must be immediate if conflict arises. So if you realize that you are conflicted, you have met the person before, you have seen the person before, you must disclose that, oh, I have a meeting, I think next month with a certain group. I met them online. I didn't know them. We haven't met physically, but I met one somewhere, and the moment I saw his tag, I realized that these are the people I met online. So I said, do you remember this name? Does this name resonate with you? He said, yes, 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 yes. So in the next month, when I meet the other party, I will inform them that I met this person here, so that they don't think that later somebody will not go and raise an issue that, oh, this person met somebody, and because of that, maybe they have done something behind us. So that you don't wait for the parties to raise that issue. If you have met someone within the parties, if you have seen them somewhere before, disclose it. If the parties want you to continue, they will allow you. If they don't want, leave. Don't only consider maybe what your gains from the process. Then conflict of interest, full disclosure of prior dealings. If you have had any prior dealings with the parties, disclose. Avoid dual professional role. So serving as a lawyer, at the same time you want to be the mediator for the parties. It doesn't work. If you become the mediator, you can also go and serve as a lawyer. So that is what you must understand. If you become the mediator, you can be the lawyer. So avoid doing dual roles. Avoid doing dual roles. Avoid. Then consent alone does not always cure conflict. So sometimes the fact that they have consented does not cure the conflict of interest. So you must also understand these matters. And sometimes if you realize that these are serious matters, recuse yourself from any issues. The confidentiality encourages openness and protects settlement discussion. So mediators must not disclose information, must not disclose admission made during the session, settlement proposals, caucus discussions. So you must understand. So statutory backing is the ADR 2010, meaning proceedings are confidential. Mediators cannot disclose session information. Even if you are subpoenaed before a court to come and testify on certain issues that you were privileged to during the mediation. When you go to the court, let the court know, thank the court that they have invited you and they are interested in mediation. However, you are bound by Section 79 and Section 78 to disclose any discussion that happened in the mediation process. And for that matter, the only thing you can do is that to confirm that these parties came for mediation and the outcome that they are having is the outcome that reflects what they agreed during the mediation. And that is it. So you don't move further with anything again. The limit of confidentiality. Confidentiality may be limited where required by law. So sometimes confidentiality is limited based on the limit that has been given to you by law. So some laws, for instance, you are in a discussion, somebody saying that you will not get home. I'll meet you on the way. I'll do this. You hear from me. You do this. So some of them may be veiled threats. Probe. If you realize that the people are serious about the situation and it is dangerous, get the security involved. Don't use confidentiality and let somebody die. No. There's sometimes fraud is being planned. People are, upon engaging the parties, realize that even the transactions are flawed and they are planned to ruin the other parties. You don't need to. Then public policy requirement requires intervention. Those ones you cannot. So parties must be informed of these limits. So if you look at, for those who are in Ghana, if you look at the Ghana AD Act, it has been provided for. Well, the areas of matters you can disclose and matters that you cannot disclose. So you satisfy yourself with that. Participating must be free and uncoerced, so voluntary participation. Parties must understand the process Withdrawal is always possible. Let them understand that at any point you can withdraw. But we encourage that you seek through the process. But let them know that at any point that they feel uncomfortable with the process, they can find out, or they can question you, or they can withdraw. Then inform on the parties must undertaking mediator's role, nature of the process, legal implication of settlement, and risk to seek legal advice. So you must let them understand that they have to be informed. So the mediator's role is this, their role is this, the nature of the process is this, the legal implication of settlement, the outcome when they sign. These are the legal implications. And the right to seek legal advice before they sign, and even they can be represented. All these things must be available to them to know. So authority is Hersey versus Milton Keynes General NHI NHS Trust. Mediation depends on voluntary participation. You can't force somebody to participate in mediation. Then the role of legal advice. Mediators must avoid giving legal advice. You, the mediator, you are not a lawyer. Even if there is an advice that you want to give, or you want to open the person's eye on something, you can ask it in a question format. Maybe he is not aware of certain provisions. Maybe with what you are saying, can you elaborate on that? Are you aware of that there is an act called this? Then they will tell you yes or no. Would you mind maybe looking at it? Then you look at it. Have you found out what do you say about that? And in the event of this provision is applied to what you are saying, what do you think will happen? So you are opening up, you are not giving legal advice. You are just opening the person up to see certain things. You are doing reality tests and open-ended question to let the person see that challenges that they may face, rather than saying that what you are saying is not right. By law, you can't do that. You don't get yourself involved in that. Then pressuring parties to settle. Don't pressure parties to settle. Don't pressure parties to settle. Then replacing parties' judgment. Don't be replacing parties' judgment. Then encouraging independence legal advice is ethical practice. So you can encourage them, if they don't understand anything, they should seek independent legal advice or advice from an expert. Pressure to settle. Settlement should never be coerced. Unethical conduct includes coercion. So if you coerce somebody to settle, it is unethical. Exaggerating legal risk. Some of them will say that you don't know that they are even doing you a favor. When you go to court, you won't get anything. Your case can even be dismissed. Don't be exaggerating legal risk. So tell me, if with this issue, when you go to court, what are the limits that you are expecting? What ranges do you think you can get from there? Have you compared it from this? Do you know the amount of time that you're going to spend in court? Do you know when you are going to get judgment? And are you aware? Do you know that it can go in your favor and the other's favor? These are the things that you do, but you don't say that. You don't know what can happen. Your case, you can lose. This case, when I look at it, you can even lose easily, and you don't need. It is good for you to settle. You don't need to pressure the people that way. No. Stop exaggerating legal risk. Imposing mediators' preferred outcome. Don't impose your preferred outcome. Don't say that as a mediator, I think this is best. No, we are not saying the word and the writing should not be done properly. But what you are saying is that what the parties have agreed is what you put it nicely for them, not what you intend it to mean, by what the parties intend to achieve. So that is what we want you to understand. Then mediator facilitates, then parties decide. So you, as a mediator, you facilitate. So mediators facilitate, parties decide. That should be at the back of your mind as a mediator, that you facilitate, and the decision-making power rests with the parties. And you must understand that. Then ethics in caucus session. Private session raise risk. So selective disclosure, manipulation of information, then over-influence by the mediator. Fairness must be maintained between parties. So when you go into caucusing, you, the mediator, must also conduct yourself properly. Don't be going there and be pushing pressure on them, because maybe caucusing, they can tell you what they are not supposed to bring into the plenary session, or you can advise them on negotiation advice, what they should be doing and how the issues can work. So don't be over-influence the process. Fairness must be maintained. Fairness must be maintained. Then ethical duty to terminate mediation. A mediator should end proceeding where settlement would be illegal. Because if you realize that parties have decided to, the people are engaged in some illegal activity, and one person brought the issue to the mediation, but upon listening to them, maybe they brought an issue to the mediation that one person is owing them. And upon discussing in the mediation, you realize that the amount that they are even talking about is something that they stole. And it's like one person have taken advantage of it. You do not need to continue. They let them know that you don't settle such matters and discontinue the mediation. Don't get yourself arrested, you the mediator. Then one party negotiate in bad faith. When you realize that one party is also negotiating in bad faith, you can end the mediation. Then violence or intimidation is present. So sometimes there is violence, there is intimidation. Who do this, who do that, you have to end the mediation. And neutrality is also compromised, you have to end the mediation. So in the ADR Act, mediator may terminate where continuation is unjust or not worthwhile. You can terminate the process. Ethics in court-connected mediation, additional responsibility. Procedural fairness, compliance with the court rules, accurate reporting of outcomes, and avoid judicial influences over settlement. Then professional accountability. So ethical enforcement may occur through mediation institutions. So once you belong to the having been trained by AfCCoDR and ACPSEA, we will be monitoring you to see whether you are adhering to various standards. So mediation institution, professional disciplinary bodies, courts, supervision, contractual liability in extreme cases. So court will not enforce agreement obtained via fraud, coercion, or misrepresentation. Then future ethical challenges, emerging challenges, online mediation confidentiality, cross-border mediation standards, mediator accreditation system, commercialization of ADR practice, and also international standards, and also Singapore Convention on Mediation, and also trial law and on international mediation. All these things, emerging trends, you must take them into consideration. So key takeaway, ethics is the foundation of mediation legitimacy. Without trust, mediation cannot function. Then the mediator integrity determines credibility of the process. So in conclusion, ethical mediation ensures fairness, confidence, and enforceable outcome. Now, any question or discussion? Please bring them up. Any question on this ethics issue? Because somebody may say that, what if the people bring me gifts? Mediators do not accept gifts. Any question? Are we there?
Yes.
Okay, but we don't have questions. Okay, that is fine. Right. Okay, thank you. Now, can we have someone reading what is there for us?
Yes, sir.
Yes, please go ahead.
Okay. Case 33. Background. Okaja and Numo owned neighboring farms. Recently, a dispute has arisen over the exact boundary between their properties, affecting the use of a water source that both farms rely on. Issues. Okaja claims Numo has encroached on his land and diverted the water source. Numo argues that the boundary is clearly marked and that Okaja's claims are unfounded. The water source is vital for both farms, especially during the dry season. The requirement for mediation: to determine a mutually acceptable boundary and to agree on the fair use and management of the water source. Thank you.
Okay, thank you. Great. Can we have a volunteer? Okay, yesterday you didn't do the mediation sum, so today you are the mediator. So can we have a volunteer for Kada and Numo? Hello?
I think I want to volunteer as Okaja.
You be the mediator. Or you want to be Okada? Okay, if you want to be Okada, okay. Mr. Yenchi Okada. Christy, you be the mediator. Then who will be Numo? We want Numo. Any volunteer or I should mention name? Okay.
I'll be no more.
Okay. All right. Gloria, right? Okay, so now you have the floor. Christy?
Yes.
Yes, so the three of you have the floor. Christy, the mediator. Then you have your Keja as Mr. Irenchi and Numo as Gloria. So go on, start your mediation.
Okay. Good afternoon. Welcome to AfCCoDR. This mediation session this afternoon. You are all welcome, and I want to thank you and commend you at the same time for choosing mediation as a process to resolve this dispute between you guys. And then I also want to assure you that everything we discuss here is going to be confidential. Whatever we say here will stay here. And then also, I also want to inform you that I'm a neutral person. I'm not going to take anybody's side. And this discussion here is totally voluntary, as you can walk out at.
Okay, Christy, so you can start it again. When you welcome them, you didn't mention your name. You didn't let them introduce themselves. So
Okay, so let me take it again.
So you can welcome them. So welcome. My name is this. Then you continue from there. You also get to know their name. Then before you add the rest, so start again.
Okay, welcome. My name is Christine Balo. For the purpose of this discussion, I would like to be referred to as Christine. I would like to know what your names and your various positions as well, and then how you would like.
Thank you, Madam Christine. I am Krapa Ukaja, the one making the claims.
Okay. Thank you very much. Please, the other party can introduce yourself.
Thank you so much, mediator. I'm Numo, and I would love to be referred as Numo. Thank you.
Once again, you're welcome. Thank you very much. And for the purpose of the discussion, I would want you to know that this mediation section is totally voluntary. Nobody would be forced to do or say whatever, anything else they do not want to say, or agree to anything they do not want to agree to. Also, I would also want to assure you that this discussion is totally confidential. Whatever you discuss or say here will remain here. Also, I would want to inform you that I'll be a neutral person. I'm not going to be swayed by anybody on or anybody's side. I'm here to facilitate the session and help you communicate to arrive at amicable resolution. So now, please, Mr. Okaja, please, can I hear your side of the story?
Thank you, mediator. I'm grateful for the opportunity. And I pray that we'll be able to resolve this at this meeting. First and foremost, I want to present the side plan of this, and I think you can call me OK. Krapa Okaja, OK. I just state that the said land that is in contention is 100 acres. It is situated on the Amiaso side of the road leading to Bibiani. In fact, the place is bequeathed to us by our ancestors, and then we've been farming on it. The river Kuta is the source that we all, it used to be the boundary, but from the map, from what I've been told, the boundary trees, some fences had been erected over there. So, and the boundary line is over 50 buffer meters, 50 meters beyond the buffer zone of the River Kuta. Over the time, we've seen that Numo and his family members have been encroaching on this land. They first harvested the trees around the small stream, and then without recourse. So we are bringing the issue here for us to address it so that we find an amicable solution to it. We are all in the same town. We don't want this issue to degenerate. So we are for peace. I think me and my people are for peace. Thank you.
Thank you very much. Respondent Numo, please, can I hear your side?
Yes, thank you so much, mediator. For me and my family, we've been on this land for the past 5 years. Yes, we have found we found the other farm already in existence and operating. But from the time we acquired the land from the authorities, the boundary was already set, and the surrounding farmers around, they already know where our boundary is. And this water source is within our farm. And for the past 5 years, we've been farming, winter maize more especially, and we haven't had any challenges with regard to usage of this water source. And so this is water source that is within our boundary, and we want to ensure that this continues and not affecting our business. So my position really is to ensure that we are left to use this water source and not disturbed every now and then when we want to use it. Thank you.
Okay, before we continue, I omitted confirming your authorities if you are in the right position for this mediation session. Do you have the authority to decide whatever the outcome of this mediation is? Claimant, please, can I hear you?
Yes, I'm fully in support. I think that's why I'm here today.
Okay. Also, respondent, please, can I confirm your authority?
Yes, mediator. Thank you.
Thank you very much. Mr. Okay, so if I heard you right, you said the land you and Mr. Mo are having neighboring land, and then the water has been there, the river which you guys use, both of you use for your irrigations, has been there since ages. And you want to confirm also the boundaries of the land. Please, did I capture everything there?
Just to say that you did, but just to say that the boundary is already there. The boundary is actually 50 meters away from the buffer zone. I mean, the river has a 50-meter yard of a buffer that no one is supposed to farm there. Now, their boundary is beyond that buffer. But as we speak now, they've encroached on that. They've cut down all the trees along the water source. And I think if we don't take care, they will even claim to the other bank of the river. This is why I have brought this issue, and then we are before you.
Okay. Mr. Nimo, our respondent, please, I heard you, if I heard you right, you said when you purchased the land, the boundaries were already in place and you don't think you have crossed the boundaries. So you see no reason why you are to relocate your boundaries for. Please, am I right?
Yes, mediator. Thank you.
Okay. So please, Mr. Okaja, please, what are you looking out for at the end of this session? What do you want to achieve at the end of this session?
Yeah, as for us to resolve the issue of the boundary so that they revert to the original boundary and not encroach on that buffer strip near the river. I think if you cut down all the economic trees there on your land and you are also attacking the buffer, the trees, giving shade to these water bodies, I think you are not being fair to nature and, of course, being fair to all of us. And in any case, that buffer strip doesn't belong to any of us. It's ours. But then we have just respected the environmental rules that these river source, since it serves all of us, we need to do much to protect it by not harvesting the trees there. But then I think Mr. Numo and the others have arbitrarily taken the rules into their hands.
Okay, so please, at the end of the day, you want them to reset their boundaries, right? And then stop cutting down the trees. And then at the end of it, or you want to maintain your relationship with your neighbor.
We want them to respect the original boundary lines.
Okay.
You get it?
Thank you. Mr. Nmo. Hello.
Yes, thank you so much. I have the documentation. I think everyone has their own documentation. Where I'm clearing the land, I am clear certain that it is part of my land. And what I do with it really is not something that someone should come and say, no, the environment. I know how I'm going to keep my place and my portion, of which that whole area is part of it's in the land titles that are given by the authorities. So I don't see any reason why someone should come and uh, give me those instructions. And I've got a project that I need to work on and expand in that area. That's why I'm clearing it. So for me, as far as I'm concerned, I have the authority and I have the papers. Thank you.
Okay, so please, I heard everything you said very well. I just want to confirm, like, what do you want at the end of this session? At the end of this mediation, what do you want to achieve at the end of the day? What are you looking out for?
Yes, thank you. For me, really, I want to continue with my project, and if anything, then we need to go and have it clarified at the Ministry of Lands to find out really who is responsible for that place. As far as I'm concerned, I am in charge of that place. I was authorized. I've got the authority, and what I do with it really should not bother other people for now. Thank you.
Okay, thank you very much. Please, at this point, if you wouldn't mind, I would want us to have a caucus, which is where I'll meet each individual differently, separately, to discuss about this issue privately, and everything we discuss there will remain private unless otherwise. Is that okay with you?
Yes,
Yes.
Okay. Isaac, can I go to a separate room, or we should just use it like that?
Use here like that. Pretend as if you are doing caucusing with each other.
That's fine. So please, I'll go ahead with Mr. Okaja. Mr. Okaja.
Yes, Madam Mediator.
What if the Mr. Numo refused to respect the boundaries of the land which is close by the water, and refused to put a stop to his project that is working on around the water?
Let me pause you here. You are in caucusing with the parties. So
Yeah.
when you go to caucusing, you welcome him. So thank you. Thank you for your sharing your insights with all of us during the plenary or the joint session. I understand maybe there are things that maybe you have not shared with us even at the joint session that you may want to share. So here, please feel free and share with me. And so, what do you really want to see as an outcome of this process? Then, or have you? Is there anything that you have done about it before today? You can share with me here. Then the person will start talking, but do not go and talk about the other person where you are now saying that what if the other person doesn't agree? How does that concern you as a mediator? Because you are now with them. So you are now with the person. So talk about the person, the issues that he has raised, and what are the things that you want to see? What is he looking for? What are the concessions that if he sees from the other party, he is able to agree? These are the things that you discuss with the party, not the line of way that you are going. That what if the person doesn't agree? Then it means that the mediation The person will just tell you that. Then I also not agree. The mediation will be over.
Okay.
So that is to go on.
So, Mr. Okaja, welcome to this private session. I appreciate for how far you've shared with us during the joint session. I understand that certain things that you couldn't share with us. You can rest assured that during this private session, whatever you share remains here unless you want it to be shared outside this session as well. So please, you can tell me what you want at the end of the day, at the end of this session, what you want to achieve at the end of the section.
Okay. So thank you, Madam Mediator. The truth of the matter is that this land was bequeathed to us by our ancestors. We've been farming for it. In fact, my grandparent farmed on it, great-grandparent farmed on it, and then they bequeathed to us. But our chief, who recently was enthroned, just sold this bit, the boundary bit we are having with Numo and the others. Now, the issue with it is that we have identified the water source as a critical one. So after years of I think some years back, we had bushfire, and we intentionally planted economic trees there. Some economic trees there that is supposed to yield, and also help us. Then, out of nowhere, when this land was sold, Numo and their family just cleared the land and then cleared the economic trees without even giving us anything. You see, it doesn't work that way. So, and of course, what the project they are doing there doesn't actually wouldn't help the environment in the place. We've been complaining about they putting in place strategic things to ensure that waste, the land is managed well. Of course, it's not our land though, but then they shouldn't do things that will pollute our river source and then also affect all of it. So we just what I'm looking out for in this mediation is that at the end they should respect the boundary. At least 50 years, they should keep that buffer strip. We plant trees there, replant trees there. If there is any way they could compensate for those economic trees, they should also share, because those are some hardwood, redwood, and all those things. And we know the value in the market now; it's gone up. So if they could share some of the monies with us, it won't be bad. And then also they should also be conscious with doing things that won't affect us that much. I mean, environmentally. So this is what we are looking out for.
Okay, so since the issue has been arising, has there been any attempt to resolve it? Has there been anything that has been done about it?
Yeah, we took it to the Odikro of the town, the chief who sold the land to Numo and the others. And then, in fact, because he had interest in selling the land, anytime we went for the meeting in the traditional council, the verdict hasn't actually gone. We are not so much happy about the verdict. He dilly-dally about the case, and then he said that he has sold the land, and then, we are not too happy about how things are. So, where we are now, we feel with what I've stated earlier on, if you are able to put in place stopgap measure, then at this mediation meeting, we come out with plans that they respect the buffer strip. And of course, the source of the river that we all share, I think it will help us. Then again, if they could share some of the economic trees, and of course, replant the trees along the rivers. This is our call, and this is why we are basically here today.
Chief. So, assuming that they've been able to replant some of the economic trees, but not move back exactly as the 15 meters you are saying, Would you be able to accommodate that?
So the EPA in the law, I mean, with the freshwater sources that we are supposed to respect, by law, we are supposed to respect that buffer strip. So I don't know why Odikro sold that land, including that buffer strip, and then Mr. Numo and the family are encroaching on that one without actually giving that space. So it is not me saying they should respect it. It is the Odikro, and per the boundary that we share, I think we are all not supposed to encroach that buffer strip. We need to respect that buffer. And if you claim that water portion also, the river also belong to you, then it means tomorrow I need to be coming to you to pay to use this same water that we've been using all this while. You get it? So these are the realities on the ground.
So please, I'll be back to you very soon. Let me meet Mr. Numo shortly. I'll be back. Thank you for sharing. Mr. Numo. Hello.
Yes, mediator.
Please welcome to this caucusing. I appreciate you for coming this far. And then I would want you to know that whatever you are going to be sharing this private section will remain here until otherwise. And then I understand that some things we were not able to share some things during the joint session. Here is the opportunity for you to share them and go into details, some private details you'd want to share so that in order to consider the position of
Thank you so much,
the
mediator.
what
Yes,
you are.
from my understanding. Sorry?
I want to know what you
Yes,
are expecting.
yes. We are concerned about this issue as well because what we don't accept is that these people, Mr. Okay, has not even consulted what our plans are. They are defensive about the boundary without understanding really what our project is. And we have been had talks with the chief, and he understands our project. And this land, when we cleared it, we looked at the economic benefit that will accrue to the whole, the community. If we look at this, our community, a lot of people have got nothing to do. The youth are just sitting and they are not doing anything. So our project really just wants to put up avocados. In the next 3 years, we should be able to harvest, and people can order those avocados and sell, to the surrounding towns and earn something from that business. So really, the avocados have also economic value, and we're looking at how it can also sustain the land so that we don't lose the environmental aspect of our land, so that they're able to benefit. So if only they can consult us, know what the plan is, we are still within our boundaries. Our legal documents actually portray that, or show vividly that this is also part of our land. So what we do with it is environmental issues. That's why we are putting up avocados. And I don't know whether he even went to see what is happening now, because the project is almost halfway. Were they last in that place? Thank you.
Okay, so please, would you mind if you could share this when we go to the joint session so that he'll get to understand you from your perspective? Are you comfortable
Yes,
with sharing so that you'll be able
yes,
to explain maybe
thank you.
just perfect. So thank you very much. Thank you for sharing. Um, So, Mr. Numo, please, would you like to share it yourself? You would like to talk to him about this project, the business, what the benefit it brings to the community, so that he will be able to understand you from your perspective as well when we go to the joint session? Or you want me to start and then you come in?
Yes, please.
Which one?
You may start, please. Thank you.
Okay, so let's all come back together to the joint session. Mr. Okay and Mr. Numo, welcome back from your caucusing session. Hello.
Thank you.
Hello. So we've had our extensive discussion during our caucusing session. I believe everyone has a point. I heard what everybody said. So, Mr. Okay, Mr. Numo would like to share something with you for you to also understand from his perspective the kind of project he's working on, the kind of benefits, to see if you'll be able to see things from his perspective as well. And then we take it from there.
So now when you come back like this, you welcome them back. Now, as I met you, I've met you to have a discussion with the two of you. So now, who would like to go first in bringing their perspective on board? Then you allow them to talk. Rather than maybe you going into what maybe the project that he is doing. No, he has something to say. If he has something to say, okay, Mr. Numo would like to share something, then we take it from there. Not to talk about his project. It means that maybe you are about to share what he discussed with you. You get that? Mhm.
I get it. So, Mr. Numo, please kindly share with us what you have to say.
Thank you, mediator. For as a representative of our farm, I just want to indicate that I think I understand the concerns of the environment, and this is something that even us we are aware of very much, and we've had talks also with the chief over the same. That piece of land, as far as we are concerned, is within our boundary, and we have a project that takes into consideration all your concerns to do with the environment. And for the past 1 month, we have planted avocados. We are almost halfway of the whole stretch where we cleared the land. And it was for a good reason, really, because we looked at the economic status of our community, and we thought if we put up avocados, that would help the locals to buy from the fruits, and also be able to sell within the surrounding cities and communities, to earn an economic, an income from that. So really, we are looking at how we can support not only ourselves, but also the locals. And also the trees, really, they have that benefit to the land, and it can sustain, it can retain water. So really, there's no much disturbance. And we are looking at how maybe we can inform the whole community. Maybe we were not informed by the community. Maybe we can inform so that there's that ownership as well in the project, because really these are the projects that can support the communities, not only just ourselves, but it takes into consideration all those aspects. So, and I think if we consulted, maybe all these issues would have been ironed out. But I'm also suggesting, if you don't understand my boundary very well, let's go to the Ministry of of lands and also through the chief to just ascertain what this whole issue is. But as far as the environmental concerns, the environment is concerned, and your concerns as well in maintaining it and being sustainable, I think we have the project really caters for that. Thank you so much.
So, okay, please, I believe you heard what Mr. Numo said. Please, what would you have to say to what she shared? What's your take on what she shared?
Well, thank you very much, Madam Mediator. From the look of things, I think our interest is that the economic trees were planted by us to protect the water source. Now you cleared it, and now you just planted some avocado seedlings there. This is going to take a whole lot of time, and I'm saying that be that as it may, if not even respected the the buffer zone rules of the Environmental Protection Agency that covers our land here. But then, with the explanation she gave, it's one way still says that she owns the whole river source. I mean the water bodies, meaning that buffer zone strip is not going to be respected. I have no qualms about the planting economic trees, but I'm saying those trees that they cut, the timber logs that they cut, and all those things, the mahogany they cut along, they cleared on that buffer strip. If they could share proceed with us, it will help. Then again, if not shared with us, though, but then from what we are hearing on the ground, the factory they intend to build, the farm factory they intend to build, wouldn't actually help us in the long run, but it's up to them. We've taken this case, if she'll remember, and she'll be sincere to tell us, Odikro, the way Odikro handled the case, the chief handled the issue, didn't help that much. So maybe from here, if we are unable to, but we pray that we will settle this case so that we do not escalate it there. Odikro is our chief. We revere him that much. But we feel in this matter that buffer strip shouldn't be encroached on.
Okay, so if I heard you right, you'd want to know the proceed of the economic tree that they did cut off along the river bank. You want it to be shared among you, which I'll give her the opportunity to explain that to you. Then you guys will talk about that as well. And then you still want the boundaries of the river to be respected, in as much as the avocado trees are going to still serve as a protection to the river at the end of the day, but you still want the boundaries. If possible, the boundaries should still be respected. Mr. OK, did I get that right?
Yeah, you did. Just that the boundary, they are claiming ownership of the boundaries, including the river source. And I'm saying our boundary actually ends there. And the agreement we've had way back is that we are not going to encroach 30 meters, 50 meters of the buffer strip. We are going to respect that. The submission Mr. Numo is making seems to say that, well, they still own those areas and including the river source and all those things. I think that's the area of our contention. And of course, the economic trees that they cut down there and then sold, if they could give us some of them, because it's my great-grandfather who planted those trees there, the intention that it will protect these river sources, our river source.
Okay. Mr. Numo, please, would you mind sharing with your colleague, your partner here, the other party, will you mind sharing the other party your land boundary details you said you do have a document. Did you show document when you had a meeting at the Odikro? Because he is saying he doesn't have, you are claiming it is, the boundary is your land. So can you help him, convince him that the boundary is yours?
The plans are there. Whenever he has time, he can come and see them. Yes. And if he's concerned about the trees that we cut, we haven't taken them anywhere. If they want to come and get them, they can get them. For us, they are not ours. All we know is that that is our land, and if land is on title, really, there's no question about it. Thank you.
Mr. Okay, I believe you heard that. What do you have to say?
Well, I'm hearing for the first time that we can come for the trees. The last time we tried, his security people accosted us and arrested us. So we just want that assurance that you give us back those economic fees they fell on that strip, so that we'll make good use of it.
Okay. So since she said you can come for the trees, and I believe you've also agreed to that. The second issue is that the land boundaries, as it states about the protection of the tree, the trees are there to protect the water. Now they've planted the avocado there. Yeah, ready to compromise on that, since the avocado tree at the end of the day is going to be an economic production for the entire community. Please, did I get that right? Mr. Okay.
Yes, Madam Mediator.
So,
In
and
fact,
then
her
also,
submission in Mr. Numo's submission, he didn't actually agree that. He said that land that they planted the avocado, they still make the claim that it belongs to them. And then, although they have this frugal intent of 8-7 the whole community.
please, your line went off. I couldn't get everything that you said.
Oh, sorry about that. So I'm saying it's a good thing Mr. Numo mentioned that the trees are there for us. But the last time we tried going for the trees, his security people accosted us, and we actually didn't like the outcome of it. You get it? So if she can assure us and then bring us the economic trees, why not? We will be most grateful to have them.
Mr. Numo, please, the party is asking, can you assure that the next time they go to, they have an attempt to take the trees, there will not be any security prevention as well?
Thank you so much. I'm a very formal person. As long as you give me a notice, I think I'll be fine with it. Yeah, because last time people just came and knocked in our gate, and there was that commotion. So for me, really, if that can be done by way of notice, at least even just a week. I'm not always around, but that would be ease everything. Really. Thank you.
Okay, thank you very much. Mr. Okay, please, are you okay with that? Please, are you okay with giving a notice?
Yeah, I'm okay with the assurance.
Please, then also, can we agree on a time or on a specific time that we can check the documentation of the land that Mr. Numo is saying the boundaries belong to, so that we just confirm that in as much as the chief has sold and you are also saying the boundaries is not at the right place, she's, as she said, the boundaries are hers. So she said she has documentation, you can come and have a look at what we want. Can we both agree on a specific time and date to have a look at the document to assure both parties?
Thank you, mediator. I'm available this week, Friday. Not yeah, Friday, anytime. Thank you.
Let's have
Okay, I'm
Mr.
also available on Friday throughout the
So
day.
Friday. Okay, so let's agree on a specific time in order not somebody to say that I'm available the whole of Friday, but around 12 I went to grab something, I wasn't able to make it on time. So let's have a specific time, 12, 1, 3 p.m. What time exactly will be favorable for both of us? Both of you.
I think 11 a.m. is okay with me.
Mr. Numo, 11 a.m. is it okay with you? 11 a.m.
Yes, 11 is fine with me. Thank you.
So from there we can determine that the boundaries Mr. Numo has is the same as what is on the document. What Mr. Numo is practicing is the same as what is on the document. And then if from there we can come back to say that if the environmental protection of the line, the protection of the water body is still not being attained, then we can discuss for further management. Is that okay? So we are going to go ahead and observe the documentation to see if it matches the boundaries of the land. And then if it doesn't match, as being said, then we can see the way forward. You come back to mediation and then we discuss a way forward. Is that okay?
Madam Mediator, can we also take the trees?
Can you also
Come for the tree logs, the timber logs that they have.
Yes, we are going to agree on a time. So let's also agree on a time for that, for the tree logs. She said you can come for it with a notice. So when are you sending the notice and when do you want to go for the tree
I'll
logs?
send it tomorrow. Tomorrow when I meet them, I'll send it.
You send the notice tomorrow. And when do you want to go for the trees? The time you want to go for the tree has to be indicated in your notice as well.
Yeah, we'll free. Anyway, so we'll try. Maybe in a week's time, so that we'll come for the tree logs.
By every time. Okay. All right, thank you. So when we agree to, after the observation of the documentation, we will come back to mediation to conclude as to whether the documents are matching the land demarcations. I suggest that we do that. What do you think?
Come again, mediator.
I'm suggesting that as we are going to be meeting on Friday, 11 a.m. to observe, to check the documentation of the land, to check if the demarcations are correct per what you are using on the land right now. I suggest that after observation of the document, we will come back to mediation to conclude as whether it match the demarcations on the land right now or not. Then we can decide how to demarcate the water boundaries. If we have to go back to the chief or we have to involve the chief, then we come back to mediation to decide that. Is that okay?
may not be okay on my part because I will need to have my lawyer as well, and also inform the people from environment so that they are also there.
That's fine. We just want to be sure that what we have on paper is what we have on land. Because your other party is saying the boundaries is not supposed to be sold, and now you say the boundary is on your document. So we just want to confirm that. So your lawyers are welcome. Mr. Okay.
Yes, Madam Mediator.
Is that okay? Would you want us to do that? What do you think about the suggestion I gave?
Well, since she's bringing her lawyers, I think I'll also bring my lawyers so that they also sit through to see.
Okay. So, Mr. Nimo, please, is that okay? Since you're bringing your lawyers, you're going to inform your company and then he also bring his lawyer, then we take it from there. But if it be the case that the document match what's on the plan, there won't be much to do, but your lawyers are still welcome. Please, is that okay with you?
Yes, mediator. Thank you.
So thank you very much. So we've agreed on the terms that at the end of today's mediation between Mr. Okaja and Mr. Nimo, we agreed that Mr. Nimo receives a notice from Mr. Okaja by tomorrow. And then as at when he wants to go for the tree logs, there will be indicated in the notice. He said by a week time. And then also we agreed that tomorrow, Friday, 11 a.m., both parties are going to meet, and then we'll check documentation of the land to see if the demarcations on the land matches the demarcations on paper. Please, do we both agree on this arrangement?
Yes.
Okay. Thank you very much. Thank you for coming for this mediation session.
Thank you.
Thank you. Mr. Isaac, we are done.
Okay, thank you, mediator. Please, your comments. Parties first. So, Mr. Yenchi first and Gloria. Mr. Yenchi, let me hear you. How did you fare with your mediator?
Oh, I think she did well. She was trying to balance the energy. The introduction was cool. Was the sessions, the breakout sessions. I mean, the caucus also was laudable. And then although there were give and take here and there and all those things, I think she has done a yeoman's job by trying to calm us down, by trying to steer conversation so that we harmonize. We got somewhere with respect to the concessions we were willing to make.
Okay, Gloria, let me hear from you.
Yes, thank you so much. Yes, yeah, the mediator I think involved everyone. She ensured that everybody participated, and she balanced the questioning. I think there were right questions, and maybe just a few leading questions. I think I stand to be corrected, but some suggesting, I don't know whether it is the way to go, suggesting on behalf of the parties, And the summary was good. She recapped everything, what we did, what we agreed on, item by item. Was it? Yeah. So, yeah, the caucus, I think, was taken at the right time, and it was, it really brought up the issues that were not really coming out earlier in the main meeting. Yeah. Thank you so much.
Okay, thank you. So then others, Josephine, are you there? Want to hear you? Okay, okay.
Just back to the mediator, at the point when the parties said they were going to bring in their lawyers, I think she made a very discouraging mark when she said that should the things not match, it is likely not to do much for the Ninihib. I think the best approach to me would have been she would just have been neutral at that point and said that we look forward to the advice that the lawyers will give, and from that we shall be able to come to a more formal resolution. But it's like she just said, it won't do much. So in a way, I feel like she was discouraging the parties.
Okay. Let me hear Kani. Let
The
me hear from you.
mediator welcomes both parties.
Hello, Kani. Okay, Kani is not there. Hey, Mr. Hayford, are you there? Hello, Mr. Hayford. Hello. Hello. Okay. Who again? Okay. Right. So all that I want the mediator to take note is that I think that there was a level of fear in her once she was starting. She was a little bit shaky. So you have to take control over the process. It is your
Good
process.
afternoon.
Yes, good afternoon. May we know who is
Sorry.
behind? May we know who is behind?
Yes, this is Gillian.
Oh,
This is
okay.
Gillian. Yeah,
Okay, because the name here is in Phoenix. Okay.
we're at a, then I
Okay.
was somewhere attending a presentation. So I'm sorry I couldn't join even in the morning earlier. The network wasn't good for me. But I
Okay,
think
that's
a
fine.
little observation I've seen from during the mediation, when she started the introduction, there was shaking of voice. She was not firm on her speech. Two, at a point when Mr. Nemo said, oh, I would want to respond by maybe giving a notice to the other party. It was like when Mr. Nemo started by saying 2 days time, then later it went to a week for them to finalize the whole thing. So I'm not getting it clear whether parties can suspend mediation more than a week. Previous discussion, as at yesterday, I learned during mediation, it shouldn't take much time to mediate between two parties. Then it was like I'm asking a question where the mediation involved community members. And sometimes it has to also go in the process a bit. Won't it be fair to give them time or to extend it as at when the members get to understand themselves and come to consensus that, yes, let us agree to each other on these terms, and that outcome will be read to the parties. Thank you.
Thank you. So going back to what you said mediation should be done within some specific time frame. It is based on the agreement between the mediator and the parties. So mediation can take 1 day, 1 hour, 2 hours, 3 hours, and sometimes it can take 1 month, can take 2 months, can take 1 year to do mediation. So you don't rush the mediation process. If within 1 hour the parties have been able to talk about the issues and they are able to resolve the matter, that is done. But the parties can decide to go and do a background check and come back within 1 week. It is allowed. So you don't say that once you have come here, we must complete it. No, it is not done that way. So there is no specific time frame to conclude the mediation. For instance, if you are doing the court-connected mediation, if a court refer the matter to you, the court, because of the adjudication process of it and the court is involved, they give 30 days for 4 sittings. So within the 30 days, you must be able to meet at least 4 times and try resolution. So if you are not able to resolve, you have to inform the court why you are not able to resolve the matter and why the court must give you an extension of time. So that is the most important thing, so that you can use that extension to do the rest. Or if the court say that return back, then you go back. But if it is a private mediation session, during the pre-mediation or the preparation stage, you agree with the parties on duration of the mediation. Today, how many months, how many weeks, how many time do we use to resolve this matter through mediation? So you agree on timelines, that we agree to meet within 1 month and we'll meet every Thursday evening. So for 4 times to resolve the matter. And if you will let them also know that your fee, maybe I'm charging this, and if I charge this takes I'll meet you if within this fee you have the access to the mediator for 4 times, and after that, if you are not able to resolve, we'll discuss extra fees as well. So all these things are agreed based during the preparation stage, the initiation stage, and meeting the parties. All these things are agreed upon. After that, then you take it up. So mediation can take years, can take periods, but you don't need to rush it. So yes, thank you for your comment. And so the mediator did well. Only thing is that beginning she was shaky a bit, and again, she was using we. Can we agree? Can we just no? You are not the one agreeing with the parties. You don't agree. If you are at a pre-mediation session where you are agreeing on a date, on a time, those one, oh, can we agree on a date? Can we agree on a time? Can we agree on the issues that you want to talk about? That is different. But when you come to this, the time for the mediation session, parties have to agree, not you. So issues, maybe the time that they want to go and either to do an inspection of whatever, can you agree? So it's them. Can you? So can them agree on the time? Then one person may suggest, so then you throw it to the other party. What do you think about the time as proposed by the other side? Then the other side can also bring in their input. So you do not put yourself in the matter. So because it is not you, it is not your matter, it is not your case, you are not making agreement with them. You are helping them to decide. So you throw it to them. And if they say agree, you throw it to them. Do you agree to this? What about this? What about that? They must agree, not you agree. No, you do not put yourself into that. So these are some of the things that you have to make sure you do that. And the line of questioning, maybe somebody, maybe you, when you summarize the whole thing. So one thing that I've indicated is that take the mediation step by step. If you take it step by step, you see that you, the mediator, it will be helpful to you. That is why we ask you to prepare a checklist. So the checklist will now help you to know that at this stage, let me welcome the party. At this stage, let me introduce myself. At this stage, let me tell them about mediation. At this stage, let me transition. At this stage, let them sign consent to mediate. So because during your preparation, there was nothing like they will sign consent to mediate or they will sign anything, and you zoom on to the discussion. So there must be a preparation stage to allay all their fears, build rapport with them, and tell them about what mediation is about. If you do all these processes well, at the end of the day, you don't need to do much. You don't need to do more. You don't need to do worry yourself about certain things because it is a process that you are managing. So a mediator must be a process expert, a process expert. So you run them through the process. So and use their own words against them. That's all. So do I heard you saying this? Can you elaborate on that? And then you ask the other party, what do they think about what this person is sharing, and what about their views on that? What do they intend to do? What do they intend to resolve today? What do they intend to achieve from the mediation? Then your line of questioning should be something that brings out the issues. So what I'm going to do now is I'm going to show the first video I showed with you again. The first video I showed you again. I'm going to share that video with you again. So with this one, I want you to watch as your work, the work that you are doing for me is that as you are watching this video, I'm not going to play, I'll play maybe up to 25 minutes. Once you are watching, please take note of the line of questioning of the mediator, the process that the mediator used. So list the process that the mediator used that you think is good for you, then how the mediator managed those processes. So that is what I want you to do for us. So I'm going to start the video again. This was the first video you watch.
To the mediation session.
I hope you can hear the voice, the sound.
Yes,
can you hear
sir.
the sound? Okay, so go ahead.
Himself. The mediator thanks the parties for choosing to use mediation as a possible solution of their dispute. After a formal introduction, the mediator explains.
So you see, the first time when this one, the mediator is welcoming the party. So he shakes this person's hand and show where to sit. He shakes this person's hand and asks the person, okay, you can also sit here. So right from the beginning, he's setting the pace. He's directing them where to sit and where he will sit and everything. And he's trying to also build trust with them. He shakes this person's hand and he shakes the other person. So to show that he is not biased against any one of them.
Principles of mediation, in particular, impartiality of the mediator, voluntary basis of mediation, and the
Prof.
Hello.
Can you please start it again?
All right. Okay.
Thank you.
The mediator welcomes both parties to the mediation session and introduces himself. The mediator thanks the parties for choosing to use mediation as a possible solution of their dispute. After a formal introduction, the mediator explains the principles of mediation, in particular confidentiality, impartiality of the mediator, voluntary basis of mediation, and the rules of a mediation session. Both parties are asked to approve the rules and whether they need any explanation of the principles of mediation. There are no questions. The mediator stresses the fact that all the principles have been described and explained in the written contract that has been signed before the session. The mediator also explains that both parties are the only ones who are responsible and able to find the solution of their mediation. After this introduction, the mediator asks whether there are any questions.
Thank you for agreeing on a place and time to meet and for being present today and very accurate. Thank you both. Now, as you know, my name is Georgi Olenkov. You could freely call me Georgi. I prefer first names. And I do work for CDR Associates as a professional mediator. it would be my honor today to assist you in trying to solve your commercial dispute amicably. Now, just very briefly, prior to beginning with the actual negotiation, I ought to say that today we'll be reasoning out solutions for your commercial dispute so that the present situation within the company you're holding together will be altered in a way that will not affect adversely any third parties, the functioning of the company itself, or the provision of quality services, which you both stated in the pre-mediation discussions and as being of utmost importance for you. So now I ought to say that mediation is an entirely voluntary process. You're here because this is your business decision and your willingness to try to reason out jointly solutions for what you're facing. I do not have the authority, nor will I attempt at any point to make any decisions on your behalf. I'm not here as a judge or an arbitrator. And also, I will try to maintain throughout the whole session my utmost impartiality. So please know that I do not hold any preconceived biases towards any solution to your commercial dispute or towards one of you over the other. So should at any time you feel that my impartiality is compromised, please bring this behavior to my attention and I'll try to alter it. Once more, you're here because this is your mediation. At any point, you may decide to stop negotiations, replace the mediator, which I strongly advise you against, and also pursue other means of settlement, though I strongly encourage you to give a chance to our meeting today. So, the floor will be yours in a minute, but first, just two procedural guidelines. The first one being the following. At some point, you may want some break from the joint session and you may wish to meet with me privately in a separate meeting or the so-called caucus, where we shall discuss matters that, for instance, you feel uncomfortable to bring out in the joint discussion. This is an option for you, so keep it in mind. And also, what my experience tells me is that it's good to start in the very beginning of the session with some uninterrupted equal time for either party to explain their perspective, how they perceive the case at hand, what brought them to mediation. So should this idea for uninterrupted equal time be okay with you?
Absolutely.
I would like to begin in this way. All right, then thank you. I think we can start. And Mr. Sharp, you were the initiator of this session, so maybe you could begin with the elaboration. But prior to that, just tell me who you are, what brings you to mediation today, and give the floor to Mrs. Smith to do the same. Then, if that is okay with Mrs. Smith, you can begin with your elaboration.
Okay, thank you. So, my name is Jan Sharp, and I'm the shareholder of the company No Need to Pay Limited. I have the 50% of the shares, and
I have
my
the
colleague,
other 50%.
Yeah, she's the
shares.
that's
My
the
name
problem.
is-
That's the biggest problem.
Well, my name is Julia Smith, shareholder in No Need to Pay.
Yep. Unfortunately.
All right. So please.
So the company, we are working in the field of the tax optimization and tax consulting, and we established the company in 1992. From the beginning, the company was working very well. We earned a lot of money. We have a lot of clients, and the business was increasing very highly and very rapidly, I would say. So both of us were very happy. We earned a lot of money, so we just started to do another businesses. We bought for houses, so we work in the real estate area as well. And also, we do the training for the tax professionals. This is the activity of our company right now and from the beginning. According to the fact that the business increased very largely and very rapidly, we divided our activities between us. We are both tax professionals, so we provided our clients we used to provide our clients with our services. And I'm specialized in the client acquisitions, and she is supposed to work in the area of real estate and the training. So that's the basic situation right now. And everything was working perfect. A very long time. We were kind of happy, I would say. We were friends. Everything was perfect. About 1 year ago, something happened. I really don't know what, but something happened. We are not able to cooperate. We are not able to work together. We are not able to communicate. And right now the situation is that I'm the only one who works for the clients from the beginning till the end. I'm the only one who makes the profit of the company, and I'm the only one who does all the activities of the company. And she doesn't do anything. She's saying, I'm working for the real estate things and the training, but it's not sufficient. Right now, I don't want to be useful idiot anymore. I'm the only one who earns the money, and she's just
come on,
getting almost 50% of the profit.
Me?
No, that's the
Are
truth.
you kidding me?
Do I look like that?
The only one
yeah, I'm the only one who earns the money, the whole money. So I'm the only one who works 24 hours.
Where the money comes from? I'm sorry
from
for
the clients.
being
From
curious,
the clients, I get the clients. I work for the clients. All the clients. We are the taxation. We are the company that works for the client.
We are a training company.
Training company. It's a completely different company than I have.
Well, then maybe we have different companies.
Yeah, it seems to be. So let's finish this, settle it down.
Okay.
I will get the money and get rid of this company. I will with you completely.
If I may step in, I think this was useful. This little confrontation to just
not only useful, it's
let some steam go off. So now at such times, I always bring the parties back to the procedure that we chose together. And the procedure was the following. Each party talks uninterrupted, and then the other party explains. So please, as you know, a pencil and a pad have been distributed to both of you. So while the other party is speaking, in this very beginning of the session, please jot down any observation or remark you have. We will discuss it in detail, I assure you. So, thank you for this. And now, Mr. Sharp, do you wish to elaborate on anything further? Or
I think the most important things were said, but right now I'm the only one who works for the company, who earns the money. So I think I deserve 70% of the profit, and I think we are not ready to cooperate. Yeah, 70%. Yeah, that's the thing.
70%.
Yeah,
like
7%.
Like 7%. Like 7.
Yeah, I know the number. Yeah,
because it's not 70. I'm sorry, it's not 70 that you deserve.
70 is 70.
No.
You
deserve
you have to see it. You know it.
I do not know anything that's not
now
based
you
on
know.
the facts.
Now you know.
No, I had
So could you just tell her that, make some notes or something? I'm the one who's in charge right now.
Tell both of you that we should stick to the procedure. I know it's hard. I know you mentioned, both of you actually mentioned, even though Mrs. Smith still hasn't got the chance to explain her perspective, you mentioned this communication discrepancy between the two of you. It is visible right now, and I see it's difficult to start discussing in such an informal manner through mediation. But please, let us try in the beginning to stick to the procedure tightly. And Mr. Sharp, could you just continue if there is anything else you'd like to bring about?
Maybe that's all. I'm just the one who's working, so I think I deserve 70% of the profit.
All right, so to echo what you said and what I think grasped from your presentation, and to recap it, you are concerned that there is unequal division of labor within the company. And even though you noted that prior to the discrepancy that occurred 1 year ago, everything was functioning, or if I quote you here, working perfectly. So right now, of course, matters altered in such a way that you would like to sell the company and to divide the profit 70-30. Is this a fair recap of what you...
I think it's not only fair recap, but fair settlement as well.
All right, so thank you for this. And now I would like to ask Mrs. Smith to present her perspective.
Well, there's not much to say. Thank you for that. And yes, it is. It was and it still is very hard for me to be here to address those issues. But we are where we are, and we need to confront what brought us here today. I can agree that, yes, we initially were very profitable, shareholders of no need to pay LTD. We set it up as a business adventure, I would say. Part of the business plan in the beginning was that what we'll be doing is tax consultations, and yes, Mr. Sharp, acknowledgement to him, is good at that. I'm also good into this. So we were having clients and servicing them with our tax optimization structures. But that was at the very early stages of the company's development. Later on,
we moved on to the real estate management. And today that's like another aspect of the company. I would say like a separate division. It's like a subdivision of the company, an entirely different business from tax services that we used to, and we still are providing. No question to that.
I am providing.
And that's today.
Yep.
But in addition to today's work, we also have trainings for tax professionals, and that's entirely on my shoulders. This is part of the business that I'm in charge of, and I think that perhaps because Mr. Sharp doesn't get to see it day to day, he probably doesn't even know that it exists. But if you look into the accounting, you would see that a lot of the cash flow comes from those trainings that we provide for tax professionals.
No, sorry, Mr. Mayor, but I have to say something about that because I have the documentation, the tax documentation. There is no profit, no huge at all a huge profit from this branch of our enterprise company. Nothing. It's just it's the 30%. This is okay. 70-30. I don't have a problem with that.
Because I've heard the 70% number before. Like this has been on the table always, and I don't see it. Like for him, it seems like everything's about money, like money, and no intention whatsoever to look into the matter and where we are. We have a potential with this company. He just doesn't get to see it because he doesn't.
Company.
I can disagree, but because I've heard you argue many times the 70%, and I've never heard even once for a change any argumentation of the basis that you used to come up with the number.
Did you see the numbers? The profits of the company?
The numbers.
The client,
but
the money that clients are paying.
And you may
Did you see
be
that?
interested in seeing this document, and I'm sure that the mediator is going to be interested. This is evaluation of the assets we hold.
Well,
and
I have all the documentation that we need, and it's saying that more than 70% of the profit goes from our clients. Clients that are my
where are
business.
those clients? I don't see them.
Well,
I don't see them. I don't see clients.
Maybe
I don't
you
see
should
clients.
leave the houses and sometimes go to the office and see
You have
the
guts
people.
to tell me this? No, that's absurd.
That's the situation.
So, anyway,
see the accounts. See
what
the account. Who is paying for our bills?
Okay, I'm not going to go.
Yeah, this is the
I'm
point.
not
You're not
going to
going.
go to your road. So, my suggestion is, you don't want to work with me? Fine. I don't want to work with you either. Okay?
Perfect.
We can agree on that. What we can and should agree then is how we part. And I suggest we part with grace, which means sticking to our initial word, which is 50-50.
But the situation changed a lot.
That's the profit division we agreed on.
But from the beginning, it was 50-50. I agree. There's no reason not to agree. But right now, the situation completely changed. I am earning more than 70% of the profit of the company.
No.
And you are getting 50%.
Now,
It doesn't
if I may
make
step
sense.
in, just Mr. Sharp, please consider the initial procedure that we all agreed on. And just as I asked Mrs. Smith while you were talking, I would also advise you to jot down any remark that you have. We will discuss it in detail. Just let Mrs. Smith, should that be all right for you, to continue with her elaboration. So what else do you wish to share at this point?
I don't think there's much more to say. You see the exact status of our communication, and it's been like that for the last 12 months. So obviously we cannot work together, and I can agree that if you want to put an end to the business, all right. I mean that's where we are. Fine by me. But what I cannot agree on, and this is my position, we may discuss if we want to continue and how we want to continue, if that be the case. But if we are not to proceed with the business, and if we're to liquidate no need to pay, I'm very, very much, I cannot agree to his 70%. My position is we stick to the division of profits 50-50. That was the initial plan. I'm not requesting for more because I trust that part of that share, I have grounds to ask for more than 50%. But I have the honor to say that this was the initial plan and this still is the plan. So that's my position.
All right. Thank you, Mrs. Smith. So I actually thank you both for your patience,
React
for
somehow.
your elaboration. Please.
She's acting like generous lady, but she's
Who I
not
am.
generous. She wants 50% and she deserves 30 maximum. So it's very easy to prove it. She said she has some text documentation.
Go prove it in court, okay? I mean, if that's the conversation you want to lead, go prove it in court. Okay, I'm fine. Go prove it in court.
Then this session is useless if
I'm
you're saying
that
this
we're
way.
coming here to have some discussion, right? I mean, let's listen to him for a once, okay? He may have something to say.
No, as you said, you have the documentation. I have the documentation as well. So let's see the background and say, okay, you are earning this money, you are earning this money.
All right. I know, first of all, I understand that all of this is very, very hard for you after 1 year of turbulent communication or lack of communication to sit here at the same table and to discuss these matters with the help of a third party. I understand it's hard. I also understand that you came here quite prepared with the relevant accountancy documentation that we may easily delve into, should that be the way you perceive this negotiation today. Yet once more, I urge you to stick to the procedure that we chose and to try to go patiently through all the topics. For instance, at some point you started discussing the 30 or 70% or the equal division of the profit from the company should it go liquidated. Yet this is a solution to one of the two scenarios that you perceived, which is either continuing with the company or not. So let's just go patiently through all of that. And before we do it, let me just recap what Mrs. Smith just shared with us. And it is briefly the following. Please correct me if I'm wrong with anything. But from what I grasped, you perceive that there is equal division of the workforce within No Need to Pay Limited, that with view to the sub-branch of the real estate and to some other occupations and obligations of yours, you deserve to receive, should the company be sold, an equal amount of the profit. And you also mentioned, just as Mr. Schaub, that communication is a very important matter in your commercial cooperation. So, what my experience tells me is that it's also always very good to have some plan or some agenda to give structure to our discussion, to give some firm ground beneath our feet. So to help you with this, I came up with three main topics from what you just shared, three main topics that seem to be utterly important for the two of you today. And these are the following. First, of course, your shareholding within the company. Then the second topic would be the possibility of future business together. And of course, the third matter, communication, the word we keep repeating throughout this session. So can we consolidate that these three topics represent a fair recap of what we ought to discuss today?
I can agree to that, yeah.
So should this agenda be also all right for you, Mr. Schaub?
Yes, but I don't think we are able to cooperate in the future. But if you want to make the agenda like this, I don't have a problem with that.
We can just put it down on the flip chart just as a possibility.
Okay, then I'm okay with that.
So now that I mentioned the flip chart, one of the most useful tools in the toolbox of the mediator, I would like to write down the three main topics in this agenda that we consolidated on. So one of the topics could be the shareholding of the company. I just write down shareholding. And is this visible? Another topic may be the so-called future business together. And in this ambiance of mediation, I take the liberty to underline the word together. And the third theme, the third important topic, which you both considered as being very, very important for you, would be the communication matter. So, as you can see, I'm deliberately abstaining from enumerating the topics. You may conduct your negotiation in any manner you want. This is just to give some structure to your dialogue. So, this is the agenda that we jointly came up with. So now, as I told you, I have not enumerated the topics. It is entirely your joint choice to choose how to proceed and with which topic to enter this discussion. Please.
So may I suggest we start with the communication? I believe this is the root of our problem. I believe communication is also the way to solve our problem. And I think it would be very useful to really have a way of communication, a way of listening to each other, a way of hearing each other, a way of even being heard. So I suggest we spend some time on this because.
All right, how do you perceive this, Mr. Shah?
I don't think it's necessary. It used to be very important. We cooperate. Right now, we're not cooperating anymore. So
how are we going to solve the problem then if we're not able to talk?
So you have numbers, I have numbers. We have a mediator, so we can just make some ending with that, just to say how much money I get.
But
that's all. It's about business, just business. We don't need to talk about this.
It looks like we have an invisible elephant in the room and we are not allowed to speak about it. Then what are we doing? We're not addressing the issues at hand.
But we're speaking about what you do, what I do, what you deserve, what I deserve. That's simple. It's business. This is the thing that I can. No communication. It's important, I know. It used to be much more important. It used to be friends, but right now, it's not important anymore. Right now, I just want to finish this thing, to sell the company, get the money, put my energy, my time, and the money I earn or I get into something else, something much more important for me, much more personal for me.
Yeah, but we're friends, come on.
We used to be friends. The last year, you saw the last year. Every single conversation.
You're not making it easier for me.
Okay. I just want to settle it down. I need to settle it down.
You cannot separate things. You cannot separate personal and business. Yes, in an ideal world you can, but they're intermingled into each other. So if you have something personal that I'm not aware of, I cannot be of assistance to you.
But I don't want to talk about this.
Mr. Sharp, I understand it may be difficult to delve into personal matters, and I just wish to underline once more that we are not in a courtroom, that we are in this informal ambience of mediation where you could disclose anything you deem necessary and it will remain completely confidential. So I know you disregarded at some point the importance of the topic of communication, yet in the very beginning, both of you shared that something changed 12 months ago, that something changed dramatically after many, many years of successful commercial cooperation. So you, Mr. Sharp, from what I grasped, mentioned some personal matters and that you don't have much time right now to devote to the company. Could I just go, if that is comfortable with you, a step further, just to make sure that we are on the same page, and to ask what it is that, just very generally and broadly, that you need to devote your time and financial resources to presently?
Oh, sorry, Mr. Mediator, but I don't want to talk about this. It's very sensitive for me, and I've experienced very hard days, or months, maybe a year. So no, I don't want to. I don't think it's part of this. I just want to finish it, get the money, and work on other things that are much more important for me. Maybe the most important thing for me right now. This is my goal, and I don't think it's connected with the legal business.
I do respect your decision, Mr. Sharp, entirely. I do understand that you may be in a difficult situation you don't want to delve into. Now, what I did tell you in the very beginning is that at any time during the session, you have the option to adjourn to a so-called caucus or a private session with me. And
Yes, I'm back. I promised to play up to 25 minutes. So please, I hope you have taken notice of the steps. So let me hear you about the steps that you took notice of. Should I mention names?
A hand up.
Okay, please go ahead.
Yes. First of all, mediator welcome both parties into the mediation room by a handshake. After that, he offered each party a sitting place, indicating their comfortability. Next, by introducing himself and the center of his firm or consult or mediation center. Then he gave the rules of the mediation by telling each and every party, as they have comforted themselves, that they are open to express themselves without any fear or being intimidated. Then he also told them the rules of the mediation. At a point they are not comfortable, they can leave. And any discussion, they all discuss it on the mediation panel or table, is confidential, except maybe both parties wants it to be heard or maybe said, but it's confidential. Then he asked Mr. Sham he opened up the topic of the agenda of discussion about their company and asked Mr. Sham to start by
That you are narrating
speaking.
what happened, but I'm saying that what are the key skills that you pick from the video? That's what I want to know.
Key
skills that you as a mediator, having been trained as a mediator, you pick from the video, your key skills, that you pick from the video.
Okay, his confidence of is that okay?
Yes, okay. So let me hear from others. Gloria, Kanye, Josephine, Christy, and Mr. Irenchi.
Okay, so
Hello. Hello.
Yes, Mr. Irenchi.
This is Kanye.
Okay, can you go ahead?
Sorry, I'll be absent for a moment, and but I follow the video that you display, and you're asking this case of the mediator. I think the mediator was very professional, and he was um, um, I don't want to say. I want to say he was an active listening to the both parties when they were arguing between each other, and time to time to he bring them to stake on the process on the procedure that they agree on at the beginning. So and at the beginning also he built um I mean trust. I think that's why the party were able to speak to each other. Uh, and he also communicate very clearly with the parties. Um, he shows neutrality, and what else? And I think he along the negotiation he tried to I mean he remained calm, uh, to not react emotionally. So he stay impartial and allow parties enough time to express themselves. So it's what I noticed for
Okay.
the
Yeah.
mediator. Yeah.
Thank you, Josephine.
I think the mediator, I was very impressed by the way he ran the whole show. He was very calm and stood by his principles of being impartial at all times. And especially when it was getting a little confrontational in the very beginning, I think he did his level best to try and calm the parties and still remind them of the principles that were to guide the settlement of their matter. I think that's my biggest observation around this particular mediation. Thank you.
Okay. Gloria.
Yes, I think I appreciate the fact that he was able to reframe, yes, the statements from the parties, and also putting them into light of what the other perspective is. Yes, and also reminding every now and then when they go astray, he was able to remind them of the ground rules that were established earlier, just to make sure that the respect is maintained, and also giving chance to the other person to the time, equal time to speak without interruption. Thank you.
Okay, thank you. Who has this spoken? I think Mr. Irenchi. Okay. Okay. So the key things that I wanted you to look for is the steps that the mediator was supposed to follow. So when it comes to introduction, how did he do that? How did he conduct himself to introduce himself? That is what I wanted you to look. And when it comes to letting the parties also introducing themselves, how did the mediator conduct himself? When it comes to the ground rules, how did they set the ground rules for the discussion? Then after that, how did he transition? How did he allow them to start talking? Because you look at the way he started, he said, you brought the mediation, you brought the matter to mediation, so start first. So he shared his side. When he finished, he moved on to the other party. So let me hear your side. So these are some of the things. So when they were interjecting, he will remind them about what they agreed to do. After each one has spoken, he summarized each one of them. So once first person finished talking, he summarized it to the person that, okay, if I understand, this is what you meant, A, B, C, D. And he said yes. After the second person have spoken, he summarized and said yes. So when he has summarized both stories, he now said that from what you have said, now I say that your issues boil down to these three main areas. Then he stated them. Then after that, he said, "Can I confirm them on the chat so that we use it to serve as our agenda?" So you see that he was bringing them, carrying the people, bringing them along, and that is what we expect you to do. And that is what mediation is about, not what you think. It is a practice, and every practice demands what you do. And when you go to the courtroom, when the case is called, the plaintiff is mentioned. The plaintiff gets up. The respondent or the defendant also gets up. Once they mention their name and they recognize that they are present, then the judge moves to the representation. Then the lawyers will also get up and introduce themselves. Then the judge will look at what is there for them to do. is a process. The same way when you come to mediation, it is a process that there is a process we must follow. You don't jump and you pick here, you pick here, you pick and choose. No, you do it according to what you are supposed to do. So mediation is a structured process, and I'll keep emphasizing that mediation is a structured process that we must make sure that we follow the structure. We follow the structure from A to Z. We don't just mix the structures. We don't mix them. So if first you are supposed to introduce them, you are supposed to explain what mediation is, explain what they expect to see, explain your role as the mediator, explain their role, and confirm whether they have authority, the time, the transition, everything. Go according to the steps and make sure that you are able to use the steps to assist the parties. So as I indicated earlier, what your aim should be as a mediator is that be a process expert, be a process expert, be a process expert. So as a mediator, be a process expert, and at the end of the day, you like what is happening. Don't run it the way you want, but follow the necessary steps and the key steps, and you'll be one of the best mediators in the world. Right. So any question that is bothering your mind that you want to clarify? Any question? Any question? Okay. If there are no questions, we'll end here for today. It's 3:30. We'll end here for today, and we'll meet again tomorrow. Tomorrow morning, 9:30. So we are ending tomorrow. So please do well to come early. We'll end tomorrow. So do well to come early. We do whatever we are supposed to do, and we end it. So thank you so much. Those who have not paid for your fees, to do well to pay. You can pay through the website, you can pay through the bank or the Momo as has been shared on your platform.
Okay, start.
Sorry.
Yes, sir.
Sorry. Can you tell us a bit about the adverts that you send on the international arbitration?
The
international arbitration cost.
He said, can I tell you about international arbitration cost?
Yeah.
What was it about? How did you come across that?
I think you send it on the platform, or is it on your
It
Facebook
was a
page?
response. It was a response to someone.
Okay.
We shared our next training in July, which is 12 weeks training, and we are charging 6,000 for the 12 weeks training. And the person was saying that it is expensive. The cost is too high. So I was showing the person. That is why it is even view once. And when you look at the plan, if you don't click on the video, if you don't click on the picture, you won't see. So I was asking the person to compare other. So our class, our fees are not cheap, but we make it affordable because with 12 weeks, nowhere that you can get 12 weeks training 6,000. You will be paying around 10,000 and over. And even there are trainings that are going on, the introduction to the international arbitration that was there. That was, if you check the date on it that I used to show that person, it is 2024, even as far back as 2024, it just introduction to international arbitration. They were charging as high as $300. So convert $300 into your currency and convert what we are charging for this even 5 days training, which you see that this is more cheaper. So what we are doing is that we are bringing on a comprehensive ADR training, the one we started from March has ended last week. We are going to start the next one in July. That is what I posted on your platform. So those who are interested can join. That is a comprehensive one to train you on 12 weeks. It is not going to be a day like this. It's going to be evenings. We do it Tuesday, Wednesdays, and Thursday. We start from 6 p.m. GMT. So those who are in Kenya will be 9 p.m. there, 3 hours ahead. Those who are in other countries that are ahead of us, that will be 1 hour ahead. So we do that, and at the end of the day, we are able to achieve the 12 weeks. So it will be 3 times every week for 12 weeks. So so that will build your capacity in that area. So if you are willing to, after this, and you want to build more capacity in mediation and also add arbitration and negotiation to it, you can join that particular training. I hope you are okay with that.
Yeah, thank you. Thank you. Yes, I'm fine.
Okay, all right. So, Humphrey, thank you for joining us. Is there
Question,
anything you
sir.
want to share with us?
Yeah,
Hello.
about the
Thank you. Thank you.
criminology community, which we did it on different platforms. I was asking of how the money could be sent for the certificate, but since then I've not gotten response.
You are saying what? Come again.
The training we had on criminology and community policing.
That is not our training. So if you look at it, on the later day, I removed that particular pen. I was deleting the messages. That is not our training. It was
I
someone.
think
I am saying that it is not our training. It was someone who posted it there. So it is not our training.
I know, but maybe he's a student. I'm trying to find how I can link to get a certificate, but it's not.
And that's why I'm saying that he is not with us and we don't know that particular person.
And on the page, the main page we did the training, you can't comment except administrator. You can't ask
So
questions.
I don't know about that page and I'm not there. So you can check with that particular person.
Okay, thank you.
Okay. Okay, Humphrey, do you have anything you want to share with us before we close?
Oh no, not at all. I had I joined earlier and then we had lights out, so I went off. The lights just came back, so I joined again.
Okay.
Yes,
All
thank
right.
you.
Thank you. Thank you for joining us. Okay. All right. So thank you all for joining today. We'll see you tomorrow as we complete the training. Enjoy the rest of your day and bye-bye.